My lords,
Matter pertains to, it's a writ appeal, matter pertains to suspension, my lord. The learned single judge had granted an interim order, which is now vacated, my lord, and adjourned same day, my lord. I don't even have a date. I request, my lord, for an earlier date. My interim order is vacated. And also, my lord, I suspension. I request for tomorrow or Monday, my lord.
No, not
Monday, my lord.
30th January.
serial number 11. then. Personal inconvenience today. I have personal inconvenience today. My request for any date.
20th February.
Serial number. My lords, last week on 20th, my lords, two mining matters were heard. They were part heard at the request of the learned government advocate. The matter, they sought 1 week time. The date, at least we heard it, was on 28th January. On online portal, my lord, it's showing 28th February, my lords. This is an urgency. It's
I'll lie.
sure, my lords.
26.
In a council, there's a bereavement in the family. So the person convenience is not available.
On the ground that the senior counsel for the appellant going to appear for the appellant is not well. Prayer for time was sought for, time was requested, stand over to 12th March.
Serial number 301 30.
Yes, Mr. Yes.
Serial number 30, my lord. I pray for 2 weeks time to comply with the offer. 30, please.
So what do you want? PIL.
Please. I need to file the affidavit of the petition.
No, let it be called off. Yes, Mr. Pardon? Yes.
Your Lordship, serial number 52.
52.
Lordship, in this month, the appellant is a retirement, Your Lordship. Some urgency, Your Lordship. This is an ADA matter. Aeronautical Development Agency matter, Your Lordship. This is.
What is the urgency?
Lordship, this month, appellant is retirement, Your Lordship. That's the reason. Promotion is pending, Your Lordship. That's the reason.
Currently, my lords, this is the same item, lords, which I made a mention of on the other day. Lords, is due for retirement. The challenge is by the agency. Lords, the order of the learned single judge, where I am directed to promote it. On the other day, I said I'll make a request so that the matter, if possible, lords.
Let us see, might reach also.
I'll wait.
Serial number 49, my lord. Need 1 week time. I have to inspect the court records.
49, 21st March.
My lord, any shorter date?
Not
The date in February?
will issue there. It is a fresh matter.
Yes, my lord.
Notice will be issued. Delay is there. Notice returnable on 17th March.
Very well. Okay.
My lord, serial number 24, my lord.
Is office of this.
Serial number 24, my lord.
That is in the office objection.
Yes, my lord. We have to check if R1 objections are on record. We have to inspect the court records, man.
So 2 weeks time is granted to remove.
Yes.
Failing which the appeal shall be automatically dismissed without reference to or order of the court. Yes. Pardon? What is the urgency? Contempt. 18th March.
My lord, serial number 24. My senior colleague's brother died yesterday.
Pardon?
My senior colleague's brother died yesterday. So he has gone to Chennai to attend his funeral services. He'll be coming tomorrow, my lord. The case may be posted on Monday.
Serial number
24. Yes.
Till 24. Go to 21st February.
Yes. Okay.
Yes.
Number 23, man.
23, yes.
Kindly grant liberty to apply proper court. Kindly permit to withdraw the appeal.
Learned advocate, Mr. Your Mukundappa. Mukundappa,
Yes, Rajesh.
appellant. Files memo of withdrawal. And seeks permission to withdraw the appeal. Pereira, permission is granted, Pereira. The appeal is withdrawn without going in the merits of the case.
Liberty may be granted.
Liberty, what liberty? You have always liberty.
Mention through VC, sir. So contempt matters, still number 1. But the Vaishali agreed.
Complainant, please, Your Lordship. The order, Your Lordship, of the apex court is at page 28.
Lord, if I can make a submission, my lord.
1 minute. The state thereafter filed a review, that is at page 30. They filed a subsequent review, which is pending. But however, Your Lordship may kindly see page 77. Page 71, this is the proceedings before the government, wherein the government has said that both the arrears in respect of both the parties before the apex court has to be released. However, the order dated 24th September 2024 at page 77. Your Lordship may kindly see only one, the complainant in the other contempt petition, only his arrears have been directed to be released. And therefore, and before Your Lordship. There were two, the Sadiq and Rajaram Bhosle. The third gentleman, Arvind, passed away. So the apex court has said in respect of Arvind, it has become infructuous. However, in respect of Rajaram Bhosle and Sadiq, arrears have to be released.
Where is the direction? What direction you want to see?
Please, Your Lordship.
Which are the order? Which is the order?
The first of the orders, Your Lordship.
Page.
Page 28, annexure 8,
None. That we have, page 28.
please.
So what is that order?
That order is, I had succeeded before the.
To
single
pay
judge-
arrears of salary, my lord, with interest.
The areas of salary.
Salary with interest, my lord. If
Then?
I can make one submission, my lord, a review has been filed and pending, my lord. Even otherwise, my lord, we have taken addition, page number 77. To make the payment subject to the outcome of the review, addition has been taken. In 2 weeks' time, my lord, the matter has been forwarded to the finance department now. Addition is likely to be taken, my lord. We are making the payment subject to the outcome of the review petition, my lord. That is our stand.
That will be kept pending because Your Lordship. may
2 weeks
kindly-
accommodation may be granted, my lord. The matter is before the finance department for approval. We are making the payment subject to the outcome of the review petition, my lord.
Which review? Your review.
My review is pending before the Honorable Supreme Court, my lord. That is page number 77, addition has been taken to make the payment subject to the outcome of the review petition, my lord. Grateful.
To be next listed on
3rd week of February.
27th February.
Grateful.
One submission. There is another contempt filed by the other. That is contempt 173 of 2022. It could be connected with that.
Is once listed or not listed?
That is listed and a part of the amount has been released in respect of that gentleman.
Some date is given, let it come on that date. If date is not given to be listed.
29th.
That is 29th of January.
So that will be too short for compliance here, my
On
lord.
that day, we may request will post together.
Please.
That matter can be taken up along with this
That-
on 29th.
Number 2, to Munirajam.
The complaint.
Please return ever.
My lord, connected matters posted on 28/2.
10th March.
28/2, my lord. Connected matters posted on 28/2.
28.
And the next matter also same.
Number 3,
That is all. Right.
number 4, Ashok T.
There was a positive direction to open the bids are not open. Page number 17, my lords, is the orders of the learned single judge. At page 18.
Interim order.
It's an interim order, my lords. We even brought it to the notice of the learned single judge. This is what has happened. The learned single judge observed, my lords, that these people are in contempt, therefore you'll have to invoke the contempt jurisdiction. Therefore, we are now before. I'll take out notice, my lords. Let them respond to what.
Respondent number 3 has to respond, my lord. The direction is to respondent number 3 to open the financial bid, my lord.
Number 3 is Jilla Panchayat. Jilla Panchayat.
Please, my lords.
Please. Jilla Panchayat, my lord, respondent number 3.
Notice to the respondents. Government additional government will raise access notice on behalf of on 1, 2, and 4.
Please, my lord. 1, 2, and 4.
1, 2, and 4. The third respondent shall be served. And delivery,
And deliver, my lords.
summons by and service by and delivery is permitted. Notice shall be returnable on. When? 6th of February.
Grateful, my lords.
This number 5.
Appear for the complaint.
Rachita.
This complaint is partial disobedience of the order of this honorable court. 16-1. Yes, my lord.
Partial.
Partial disobedience of the order, my lord. 16-1-2023. And page number 14 of the contempt petition, my lord. The order.
This is
Direction to BDA, my lord.
The BDA, my lord.
after 1 year you are coming. 23rd January 2023. When this is filed? 25.
I gave the several representation, my lord. They allotted a few, I was entitled for the 27,791 square feet.
That will
But-
not extend, madam. 1 year. What is your stand?
My lord, I take notice for respondent number 1, my lord. There is a delay, my lord. It's the 23rd January 23 is the order, my lord. The petition has been filed on 6th January 25, my lord, more than a year.
Sonnet additional government advocate shall find out the status with regard to the
No,
direction.
direction is to BDA, my lord.
Direction issued by the division bench. We are not issuing notice,
Please.
only to help her. Stand over to 12th February.
The green bench matters. Still number 6, the J and B.
Additional minutes.
Yes.
My lord, my application for grant of quarrying license has been rejected by the revisional authority on the sole ground that the applied area is 16 guntas, while as per the rules, the minimum area should be 2 acres. Now, what the revisional authority does not consider, my lord, is at page 20, which is that I'm part of a larger cluster of mines. And if I'm part of a larger cluster of mines, under rule 15A, proviso, my lord, it can be considered and it can be granted. This aspect has not been considered. And this cluster map, my lord, is prepared by the competent authority itself. If my lord were to kindly see,
The entire cluster is leased to you.
my lord, no, I am part of a cluster which contains other mine owners or other applicants.
So with that,
Lord were to kindly see annexure B.
that
page
is
20.
there, it relaxes the 2 acres rule. If
No,
there is a
less
cluster,
than 2 acres. In fact, they've made
No.
grants for 20 guntas, 30 guntas.
if the demand is in respect of the land falling within the cluster,
Yes, ma'am.
then rule of 2 acres is relaxed.
It relax, yes.
Under which? provision?
Under 15A proviso, my lords. Karnataka minor mineral concession rates.
Any item.
Maybe
1-5.
15A.
Fifteen to
15A, my lords.
15A.
May I read it, my lords? Says minimum area for quarrying, lease or license or composite license to be granted. No quarry lease or license or composite license shall be granted with extent less than the minimum extent specified in Schedule 2A for the concerned mineral, provided that the state government may,
if it is satisfied that on basis of proposed production level, geographical or topographical conditions and for reasons to be recorded in writing, grant the lease over an area less than the minimum extent specified in Schedule 2A. However, in the implementation of the environmental management plan in such cases shall be in a cluster approach. Now, if my lot sees annexure B, it is a cluster map prepared by the competent authority.
There is no word cluster here.
Malad?
In proviso,
Yes,
specifically the aspect of cluster is not mentioned.
it is mentioned in the last line. Malad.
Where is that?
However, the implementation of the environmental management plan in such cases shall be in cluster approach.
Oh, I see.
No, Lord, I'll take
Notice
instruction.
for final disposal returnable on 7th. February.
No, my lord, may have this end of the month only. I'll get instructions, my lord, since it is
30th January,
obliged.
to be listed at 2:30.
Malad, I
Obliged.
request first week of February, Malad, if it is not.
Very well, my lord. I'll
7th
get
February
Great.
or 6th February, 6th.
obliged.
This writ appeal matter, still number 7. Appear for the appellant in this matter, my lord.
Delay of 23 days.
There is a delay of 23 days in filing this appeal.
Notice returnable on 14th February.
My lord, 2 and 4 government.
Only government is the part.
No, no, my lord.
No, no, no. Central government.
Learned additional government here is accepts notice on
2 and 4.
2 and 4.
2 and 4.
Number 8.
18, my lord.
Appeal by
State
state.
appeal, my lord, again delays.
Notice returnable on 14th, 24th February.
Still number 9.
Next to appear on behalf of
P.
appellant.
Vignesh.
Lord, I agreed by the order, my lord, passed by the learned single judge, dated, my lord, 19th September 2024 at page number 22. My lord, appellant is a secured creditor, it's a nationalized bank. Issued the action under, my lord, Surface Act for recovery of their dues. My lord, pursuant to, my lord, taking the position under section 14, the petitioner, my lord, assailed, my lord, approached the honorable single judge at page number 27, the writ petition. Lord, kindly come to, my lord, prayer with this sort at page number 39. Lord, writ of mandamus directing the respondent bank to grant one-time settlement facility to the petitioner to pay up to 70 lakh around in equal installment as per the directions of the honorable court. Writ of mandamus directing the respondent bank to withdraw further proceedings, not to proceed with auction of the sale proceedings, and deliver the position of the Raghavendra race bill to the petitioner. My lord, learned single judge, as an order, my lord, kindly, my lord, come to, my lord, page number 23. The petition challenging the proceeding initiated by the respondent bank provision of Surface Act to recover the arrears of the loan amount due to the petitioner. As on 31/7/2020, petition is due up sum of rupees 1,23,17,000 rupees. Petition undertakes to clear the entire outstanding due under the one-time settlement scheme. Learned counsel for the respondent bank submits that on earlier occasion, OTS was,
What's the total dues?
my lord, 1,23,17,000.
23 lakh.
Please, my lord.
Learner single judge virtually set down the terms of capital. Notice returnable.
Lord, which you have taken a physical position of a property which is positioned with us. The learns
Possession is with you. Possession is taken.
me with me. He's not even complied, my lord.
No, possession is also taken by it.
Taken by me much before, my lord, coming before the honorable single judge, before the single judge. We have issued a sale notice. That time, my lord, the honorable court passed an order without any, my lord, kindly see.
It is going to be auction
My lord, auction we have not conducted because
because of the process.
Please, my lord. In fact, he's not paid that 25 lakh. There is a directions given by the learned single judge. That also is not paid till today.
It should- Judgment, the order of learned single judge, heard learned advocate so and so for the appellant bank, paragraph. The X stated in the order of learned judge impugned in the appeal themselves reflect that earlier the bench had already rejected the one-time settlement proposal of the respondent who was indebted to bank to the extent of 1,23,17,000. And the said amount is not paid.
Not paid.
Full stop. Learned single judge in his order permitted the respondent, third party to deposit ₹25 lakh. Issued further to the bank to hand over back the possession of the property which was taken by the bank long back. Redeliver the present. Further directed the bank to redeliver the physical possession of the property which was taken long back from the petition. Notice returnable on 17th March.
Lord, I'm seeking stay, my lord, I have to.
Judgment and order of the order of learned single judge shall remain stayed till the next date.
Great.
Number 10.
Lord, I beg to appear on behalf of.
It's 6 days delay. The notice will have to go.
My lord, it's a matter, they filed a contempt, my lord, it's coming up on board on, my lord, on 28.
Doesn't matter. You mentioned that the appeal is already filed.
Yeah.
On that day.
29/1 it is coming, my lord. In fact, my lord, yesterday which you mentioned, my lord, given a date, this matter also on 29/1.
Which
Maybe.
matter?
My lord, in this writ petition, my lord, what had happened, my lord? We assailed, my lord, the two sale we have conducted. Both sale, my lord, challenged before the learned single judge. When sale took place, pursuant to that, my lord, the honorable single, in fact, my lord, I have to recover, my lord, more than 9.5 crore. Auction took place, my lord, 6 crore 25 lakh. Wherein, my lord, there are two writ petition filed because there are two property. Both, my lord, order I challenge before this honorable court because there is a direction by the honorable single judge to redeliver the property to the, my lord, the borrower which account become NPA, my lord, 2000 long ago. My lord, we have sold the property. There are 9 occasions. We are not able to sell the property. We successfully conducted the auction, and my lord, now the sale also, my lord, got it set aside by the single judge as well as, my lord, I directed to hand over the position of the property. In fact, I have to recover huge money. Therefore, my lord, kindly have it on 29th/1 because there is a contempt petition filed against me.
No, we adjourn the contempt.
Great.
17th February.
Grateful.
So 11 is adjourned. Still number 12. State appeal. There's a delay, my lord.
Notice returnable on 14th March.
Still number 13. Sumana Naganan.
Appeal against an order vacating the ad interim order granted by the learned single judge. My lord, there are no reasons whatsoever forthcoming, my lord, in the order. Kindly turn to page 31. This is the order vacating the injunction. An application for vacating was granted and allowed by this order. So-and-so may read, not page 31. So-and-so linear senior counsel representing fourth respondent submitted that petitioner's loan account, which was classified as fraudulent, has been declassified as not fraudulent subsequently. This court granted interim order on the ground that petitioner's loan account had been classified as fraudulent without issuing notice. Therefore, interim order grant stands vacated.
So the ground on which the order is granted did not cease.
That's not so, my lord.
Cease to exist.
No, what happened, my lord, is slightly different, my lord. We filed detailed objections to this, my lord. I must point out to your lordships, my lord, what is the dates in this case, my lord. There was number of proceedings between the parties, my lord. There was an OTS that was granted, my lord, at page 119. As per that OTS, my lord, I was supposed to make the payment. Page 119. At page 120, the initial payments had to be made out of a court deposit which was already there. Your lordships, go to page 120.
What was the interim order?
No, the interim order was, what they did was, the interim order was stay of proceedings before the NCLT. They filed, CIRP proceedings before me. What they did, was, the master circular of the Reserve Bank says, before you can classify an account as fraud, you must hear the party, issue notice and hear. They don't do that. They file a complaint, on 4/6/21 to the police saying that there is a fraud. The police file a B report. The B report is filed, on 6/4/22. Now, these dates are somewhat important, Complaint on 4/6/21. On 6/4/22, a B report is filed. Then, they ought to have, under the master circular directives, if an account is shown as fraud, nobody can deal with that account. No further fund can be given. No other person can advance monies to that person. It's like complete shutdown. They don't, immediately report back to Reserve Bank to say that fraud classification may be removed. They keep quiet. Then, they give me an OTS. In the interregnum, after this happens, the complaint is given by fifth respondent, which was the bank. What they do, is they transfer this debt to the fourth respondent, which is an asset reconstruction company. And now they say, asset reconstruction company has nothing to do with it. The assignment of the debt takes place in December of 22, Then in April of 23, there is a OTS given. Now, after that OTS, there are two tranches to be paid. First two tranches are monies which are already lying in deposit pursuant an order of in the arbitration proceedings. Then, they withdraw the OTS and institute CIRP proceedings. My case, consistently has been that why did you not withdraw this? So I filed a writ petition to say that RBI must take action against them and this fraud classification must be removed. In the writ petition itself, I have produced those letters. It is not as though I suppressed those letters. Your lordships will see, those letters by which they wrote to us. And please see the date also, page 129.
Where is the interim order granted earlier?
Earlier interim order, was that the proceedings.
Where is that?
I think that is not on record, in this.
So
it was an ex parte interim order.
Would like to see the reasoning in that order.
No, the reasoning, is that this account has been classified as fraud.
We don't know whether it might be something more also.
No, I'll place it, I'll place it. I'll place it.
In fact, the interim order was on the ground on a contention that they had taken. It was an ex parte interim order that the account stands classified as fraud. What was not pointed out was that in the earlier writ petition, they had contended the same ground.
That was not
that ground. I had been directed to remove the fraud classification. I have complied with
that. That was a different party.
Fraud classification has been removed altogether. That is all that I pointed out to the.
That's a different party, Kindly see the order of the learned judge, There are no reasons in the order, I have filed detailed objections. The matter was heard.
In any
no reasons are forthcoming, The law is now well settled. That if the judicial order, contains no reason.
In any event, now the position of law has been clarified by the Supreme Court also. These are defenses that you can raise in the NCLT proceedings. The writ court cannot interfere in the proceedings before the NCLT to contend that the proceedings themselves ought to be quashed. There is nothing, it is not an order that has been passed. And they have now filed their objections to the CRP in the CRP proceedings. They are participating there.
What is the petition for?
Well, in the petition, the prayers can be seen at page 49. Page 49. One has got nothing to do with the other.
I have sought, several reliefs. I have challenged, four things in the writ petition. First, is the delayed removal of fraud classification, and I have sought a direction to the Reserve Bank to hold inquiry in this regard.
My lord, you see page 194.
Result of the civil consequences of
Why there is a prayer to post the NCLT proceeding?
Pardon, my lord. Why?
Why there is a prayer in the petition to post the NCLT proceedings?
The reason, my lord, is
That has got nothing to do with the other. That is what I'm saying. What
I'll
has that got to do with NCLT proceedings?
Lord, I'll
If at
explain.
all the classification of the account is incorrect, that is a defense available to you before the NCLT. Raise it as a defense. How can you then seek an order from the writ court? Don't even file the proceedings themselves. That cannot.
I'll explain, my lord. My learned friend would kindly permit me. Yes,
Come to your prayers in the writ petition,
petition, Lord.
in
Yes.
the writ petition,
Page 49.
49.
Yes.
Now, A, B, C have become infructuous.
No, my lord, no, they are not become infructuous.
No, it has been declassified.
No, what I'm submitting, my lord, is before making the classification as fraud, the Honorable Supreme Court has said you cannot do it without hearing. So they violated it.
Now they have removed you from.
No, but I'm wanting Reserve Bank to take action against 4 and 5. That is not infructuous. My lord, they can't shut down my company acting completely in violation of Supreme Court order and master direction and go scot-free. Prayer 2 is that, my lord. Reserve Bank is first respondent. My prayer is.
The issue is pending before the NCLT, directly or indirectly.
It is. Huh? Directly, I have filed a section 7. I have filed a section 7 petition.
NCLT has no
And he has
jurisdiction
filed
so far as
objection.
RBI is concerned. My lord, what they do is not very interesting. The facts in this case, my lord. They are.
Today your dispute survives against 4 and 5.
It survives against R1. It survives against 4 and 5. My lord, one more reason why it survives is after the B report is filed, they issue me a letter.
The dispute between the petitioner
Yes.
and respondent 4 and 5.
Yes.
Reconstruction Company and Yes Bank.
Yes.
Are the dispute which are being tried by
NCLT.
No, my lord. My submission is, my submission, my lord, is this. My submission, lord, is the entire history of the facts will have to be seen in this case. Here is a case where unnecessarily and without following procedure, they first classify me as fraud. Then, my lord, that fraud, the police come to the conclusion that there's no fraud. They don't take action against that. They keep quiet for 2 years. In the interregnum, a settlement is reached.
Today you are declassified.
Yeah. No, that's true. But now, my lord, what I am now saying, my lord, is this, that between the importance is this, my lord, please see, after B report in 2022, they don't take, my lord, any action of NCRT. What they do is they come and settle with me. There is a settlement reached. OTS is given. OTS talks of 3 payments. 2 payments are monies which are already in deposit in court. The 3rd payment I was to arrange. For that, my lord, they don't remove the fraud classification. I write to them. Nearly every month I've written to them. Anywhere I go, this fraud classification is troubling me. So please remove it. They don't do anything. I write to Reserve Bank. They don't remove it. So a writ petition is filed before this honorable court where notice is issued in another company, not these companies. The minute that notice goes to Reserve Bank, they all wake up and they write me this letter, my lord, of removal on 29/24. Now, my lord, in this interregnum, they go to NCLT. My submission, my lord, this is abuse of the process of court. I have complied with the terms of the OTS. Can they go to NCLT in a case like this? Is a submission, my lord, that I'm making. And more than anything else, my lord, all this was argued. Please see the order of the learned judge, my lord. It doesn't say anything. My lord, at least my submission must be considered, my lord. It can't be that the learned judge will pass an order, my lord, today and tomorrow say I'm vacating it. No reasons are given. One of my grounds, my lord, is that the learned judge has not examined anything, my lord. Please see, my lord, what I've said in my grounds of appeal, my lord. I made a very serious submission, my lord. Page 25. The number of cases that were it would have to be reheard.
Let's serve the other sides. Not
The
us.
other, my lord, also one more factor, my lord, I'll serve, my lord. On the date this matter was taken up, all the other respondents had not even been served. We even made a submission that Reserve Bank, one of them against whom this relief is sought, is not before the court. But the learned judge proceeded to pass an order, my lord, in great haste. With due respect, I'm submitting, my lord.
The RBI had entered appearance, factually incorrect. RBI had entered.
That's not correct, my lord.
RBI,
Your RBI.
this now, my learned senior was not present on that day.
I was present online, my lord. My learned friend is
I am
not
saying.
right. I was
RBI
present online. I argued the
RBI was
matter.
RBI filed appearance. I am R4. I am the one who has to recover the money. And I am the financial institution. I am the ARC.
Let the Reserve Bank come and make a submission, my lord, about their conduct. It's important.
Notice 6th February. And produce the interim order.
I will, my lord. Lord, in the meanwhile, my lord, may request that the proceedings there
February
should be
next year.
deferred, my lord.
When it is kept.
27th February, lots after. Lots.
Very well.
Grateful.
Learned advocate, so and so and so. Miss so and so accepts. You're accepting notice.
Notice for R4.
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 The others.
They're on caveat anyway.
Caveat. On caveat accepts notice on the R.
Grateful.
1, 2, 3, and 5, my lord, notice will have to go. Would your lordships, in addition, permit us to serve, my lord, them by hand in addition?
The notice to the rest of the respondents is going to be served by hand delivery.
Yes.
For orders, number 14, Mr. Subramania Supas.
For the respondent. My lord.
Waiting for the appellant, my lord.
My lord, in this regard, the court, my lords have passed an order on 15th January. There is a slight concern with order point number 5. Point number 5 reads that in this regard, it is observed it would be open for the appellant association to collect the maintenance from its members. I would like to draw the attention in the division bench order in WA 974 of 2019. The division bench has categorically held that there is no provision to collect maintenance under the said enactment. So this is one concern that comes, it needs to be modified. And secondly, however, the amount so collected can be deposited in a separate bank account, which may be opened by the welfare association. My lord, in this regard, the single judge has clearly passed an order. That is, he has accepted the petition. The society and its bylaw are already quashed. They cannot open a separate bank account. There is really a concern that comes. This order cannot be enforced. So by looking into these two issues, I appeal that the court may appoint a receiver.
IAS. Memo correct. What is the error? What is the error?
Error is in point number 5, order number 5. It is directly against the WA 974 of 2001 division bench order. And secondly, already the society registration certificate and bylaw are quashed as per the prayer of the writ petitioner. So they don't have any provision to open a bank account. Both the things cannot be possible.
That is on merits. The memo for being spoken to cannot be accepted since the arguments raised with reference thereto is on merits of the order. Dismissed.
But one thing I would like to, my lord, I would
Have
like
your
to draw
IA.
this, if it continues, it opens a Pandora box.
Have your IA and get the modified, not on.
My lord,
It creates, there are many petitions are pending. This will create a problem.
Like clerical error or some factual error, there you can.
my lord, the interim order may be extended, my
Okay,
lord.
we'll put an IA.
Limited. It is not limited,
But stay has been granted.
No.
not limited, madam, probably. Is limited, appeal is already admitted. No, it is not limited.
Yes, my lord, thank you.
It is not limited. Appeal is already admitted and listed for final hearing.
24.
My lord, and we have another submission in the second appeal,
Yeah, next,
writ
please,
appeal
please.
893 of 2024. There's an office compliance, my lord. The objection is that annexure C and D is not forthcoming in the judgment memo filed in the writ petition, but in page number 47 and 45 of the memo, my lord.
Here the delay is to be condoned, 33 days. So then below that order in writ appeal number 893 of 24, in this connected appeal, the office objections are required to be complied. Shall be complied with within. So we can teach it. So order in IA 1 of 24 in writ appeal 893 of 24. You are accepting notice in the other appeal?
He is out of country, sir, as such.
But your
I
client,
can't able to, I know the person, he is out of country, I can't file wakalat on his behalf. If
notice,
court accepts it, I would take over the matter.
notice returnable now. In 14.1, writ appeal 893 of 24 with IA 1 of 24. There shall be notice in IA 1 of 24 as well as in the writ appeal number 893 of 24, returnable on.
Date given, my lord. 24th March is the date given. The previous matter.
24th March.
Much obliged, my lord.
Number 15.
My lords,
Prince Kumar
kindly grant us 1 week time, my lord. My senior has gone out of station due to a personal emergency, my lord.
Hey, where is the order? My lord, in this, there was a direction to the government, my lord.
I think, my lord, by this time, prayer does not
Okay,
survive for
okay.
consideration. Because in the year 2018, my lord, their grievance is that they have not made the road between the 23 kilometer stretch. And government has sanctioned for 5 kilometers, that has already been done. Remaining, my lord, we have sent proposal to the government to sanction the fund, my lord. That is in the year 2020. It's a heavy rainfall area, forest area, my lord. Every year, my lord, after escalating again, it will go. We will also ascertain the.
My lord, 18/2/2020 and 3/1/2020.
Where is 3/1/22?
Order, my lord?
Oh, 3/1/2020 order.
Yes. The second paragraph.
Order passed on 3rd January.
It is on my 3/1/2020, my lord.
So decision is taken.
My lord, no, I wouldn't know. I'll have to seek for time. My lords have observed that if compliance is not made, serious consequences will follow by order dated 18/2/2020.
Yes.
If my lord could grant me some time, my lord, I could apprise my lord as to what.
You are for?
I am for the second response, my lord, because this comes under the Jilla Panchayat and sanctioning authority, the government, my lord.
So you must be knowing
Pardon, my lord?
whether the decision is taken or not.
That I'll ascertain, my lord, because
Both
it's
of you
20, my
will
lord.
be listed at 2:30 on 6th of February.
My lord, 6, there are too many matters, my lord.
When shall we?
4th or it's
4th
earlier.
4th of February.
Obliged, my
Learned advocate, learned additional government. It's neither for as well as learned advocate. Two shall take instructions with regard to what is observed and provided in order dated 18/2/20 passed by this. So it will not survive once you say.
Please.
Nothing will survive.
Obliged, my lord.
Number 16.
By.
For the respondent.
Yes.
But one application has been filed by us
intimating your lordships that R1 has passed away during the pendency of the appeal. And it is a petition by the executor in the writ petition. So R2 may kindly be treated, my lords, as the contesting respondent.
So R1, my lord, claims to be the executor of a will. Who is R1? R1, my lord, is one Subramanya Bhatt and one Kannan. R1 in this appeal.
That's right, my lords.
Subramanya Bhatt. Subramanya Bhatt. He has passed away.
Yes.
I'm told, my lord, he has passed away. They claim to be executors under a will.
Since the co-executor is also a respondent, my lords, your lordships could treat R2 as the sole respondent and consider the appeal.
So what was the dispute? Well, the dispute is with respect to certain rural electrification bonds, which are issued not under the Income Tax Act to save capital gains. This is a case, my lord, where a rich relative dies, wills come into existence. Pardon? Wills come into existence. My lord. Multiple wills are there in this case. Different people are claimants. In this case, interestingly, my lord, they filed the writ petition on the basis of a decree in a suit without disclosing the fact that subsequently a regular first appeal has been filed challenging that order, and that matter is pending before this honorable court and is admitted. Without disclosing that fact, the court has been told that this order has become final, and on the basis of that order, my lord, the learned single judge has directed us to release the entire amount, my lord, to the executors of this will. That is the first part of it. The second, my lord, is a subsequent will has been propounded by another person, and there is another proceeding pending, which, my lord, also is pending as of date, where a subsequent will has been propounded by someone else. In all of this, my lord, insofar as we are concerned, we are supposed to be custodians of that money. Now that entire money has been deposited before this honorable court, I do not know if that has been withdrawn by these executors.
Yes, it has.
It has been withdrawn.
Released to us, lords, by the appellant itself after satisfying our credentials.
Credentials, my lord, is really not the issue here. The issue is who is entitled to it. The entitlement, my lord, is dependent on two proceedings today. A regular first appeal, which is pending before this honorable court. And second, my lord, is another suit bearing OS number 25632 of 2008, in which they are a party to the proceedings. And that suit relies on a will subsequent to the will that they claim has been proved. And nobody has obtained a probate of any will. And in terms, my lord, of the bond that has been issued, we are actually required to release money only in favor of a person who has obtained a probate of a will. Today, there is no probate for any will. Different suits have been filed on the basis of different wills. As a matter of fact, the suit which they had filed does not make the person who has filed the subsequent suit a party. But in subsequent suit, that person has made them a party. In all of this, now the money is, of course, they've withdrawn. There is an added obligation to us to pay interest as well. That, of course, is subject matter of the proceeding. But in my humble submission, Lord, there are two parts, both of which require your lordships to kindly examine. One is whether they are entitled to withdraw this money at all in the face of all these pending proceedings. One of which has not been disclosed to the court at all. And I think that, my lord, is very unfair because the order, my lord, on the basis of which they came to this honorable court
was on 27th of February 2023. That is the decree. A regular first appeal, my lord, was filed on 23rd of August 2023. And the writ petition is filed in September of 2023. But I'll...
Is the other person made a party to the proceedings or not?
Not to this proceeding.
Lords, I think my friend may kindly show your lordships para 6 of the impugned order, where they themselves have admitted the liability.
Yes,
what
because
this appeal,
No,
just if my friend does not
Mr.
mind.
Sondhi, there are two different aspects over here. One is the appellant being liable to pay the money to the successor of the deceased person. Number one. Number two, to whom he is liable to pay the same. That's all.
Yes, lords, both are
Whom he
met
is
in
liable
para
to
6.
pay, that cannot be a ground for non-deposit of the amount.
Precisely, my lords. Para 6,
I've
if
deposited
your
in
lordship
court.
see,
They've withdrawn
their
from the
own
court now.
concession made before the learned single judge.
Lord,
This
If
appeal, if
it
my
had-
friend does not mind, just for one moment.
my concession,
So
Lord,
ask for impleading
my
of-
concession was on the basis that I did not know of this RFA, which they ought to have placed before the court. They did not place this fact
Great
before the
respect,
court.
that is not the ground in the appeal. My friend should be fair to your
We-
lordship. The appeal is confined to the question of interest,
We have
whether
found
it
out,
should
Lord,
be 9% or 5.1.5%.
nothing, no interest. I want to place that regular first appeal before your lordship, which ought to have been discussed.
Are you a government company?
Yes, ma'am.
Yes, yes.
Rural electrification company, because we issue 54 EC bonds for capital gain saving, my lord. The gentleman sold the property, kept it money in capital gains, passed away. Everyone wants the money now.
My friend has now exceeded his writ appeal. In para 6, if your lordships have a look at the
You are party to the suit. To the suit, my lord. No, not to this suit.
You are not part.
In this suit, I'm not a party. In the suit, my lord, on the basis of which they made a claim before the High Court, I'm not a party. But my lord, most important in my humble submission is they were duty bound to disclose to the court that against the decree there was an appeal pending. They did not disclose it to the court. I have the appeal now, my lord. We did not know of the appeal because we were not parties. And when we find out, my lord, please look at this appeal, my lord, which was filed.
Can any of you take steps to have the other person also impleaded?
Yes, my lord. I'll take steps to implead.
lords, your lordships are referring to the nominees, my lords.
See, Mr. Sondhi, it's like this. The appellant cannot sit on the money.
Precisely.
Once the date matures, he has to pay to the person who is eligible. If he is not in a position to decide who is eligible, then in that event, probably he has to make an application to the court and have it deposited. And the money can be kept in fixed deposit.
Yes, my lords.
Now, the issue is who is entitled to the money. In interest of both of you.
Lords, as far back as 2008 in the suit where the appellant was a party.
That's a separate.
There is an order passed permitting them to release. That's my case. The liability crystallized.
No, if that person is also made a party, and if you find that it cannot be resolved as to who is entitled to it, then probably we'll direct them to deposit in.
Lords, in fact, that stage has crossed is what I'm respectfully submitting. Para 6 of the order of the learned single judge may kindly be seen. What my friend is now submitting is way beyond the scope of the appeal.
Para 6
We
is
found
on
out
the
about the
principal
scheme
amount. If
now.
my friend will permit me for one moment. Para 6, my lords, at page 7, printed page 26. Per contra, the learned counsel so-and-so representing the respondent, that is the appellant, would admit that the amount has now become payable to the petitioners, who are the executors. And therefore, in terms of the direction of this court, the entire amount, the principal amount, has been deposited before this court. He would submit that there was a tussle between the members of the family. The will under which the petitioners claimed the amount was subject matter of challenge before the civil court in 3 suits. 2 suits have ended as on date, and in one of the suits there was an injunction for a limited period. Therefore, the corporation thought it fit to withhold release of the amount on account of pendency of the suit. Now that the suits are dismissed, the petitioners have become entitled to the amount, but the respondent should not be saddled with interest. This was their submission on interest. This principal amount they deposited, it has been released to us without demo. Now, in the impugned order, the direction is to pay interest at 9%. After taking into account in extenso, the fact that there was
His stand was only with regard to interest.
to interest. And in the appeal, if your lordships just see the appeal, the entire appeal is confined to the question whether interest should be paid, and if so, whether it should be at the bond rate at 5.15% or 9% as directed by the learned single judge. And that your lordships get, just please see the grounds. And now my friend comes and says suppression on merits, etc., without a pleading or a ground.
If there's
Please
fraud,
see the appeal.
it has to be disclosed. It can't be not hidden. In my humble submission, fraud has been played on the court. By not disclosing,
Fraud cannot be alleged so loosely, orally by my friend.
It is on
Please
record
see the
now.
grounds at page 14.
RFA. How does he explain, my lord, that he knew of the RFA and did not file it before the court and got an order saying that the order has become final?
We admitted that the amount has now become payable.
Yes, it is payable.
Yes.
There's no dispute at all. We made the submission on the basis of a statement made in the writ petition that the suit has come to an end and they are entitled to the money. They did not disclose that 1 month before they filed the writ petition, a regular first appeal had been filed by the contesting defendants in that suit, and the appeal has been admitted before this court. Therefore, my lord, that issue was outstanding still. Of course, someone is entitled to the money, which is why, my lord, now I'm placing that fact before your lordships, because we discovered it now. When we checked, my lord, we found that there's an RFA pending, and that RFA was not disclosed by parties to the proceedings who did not make the others a party to the proceeding.
You are REC.
I'm REC.
Then how you are concerned with the inter-alia dispute?
I'm not, my lord, but I'm concerned about who should get the money, because one of the requirements of the bond is that I must pay it to the person who gets the right to the money.
Do you intend to implead the other persons also?
We can implead them.
No, we are not suggesting anything. If you want to implead, either way, you are liable to pay the money. That's different.
Our liability to pay is over. In the sense, my lord,
We'll examine it.
we have deposited the money and the money has been withdrawn now.
No, that the interest question we'll examine.
Lordship, examine the interest question, lord. But the real issue, my lord, is when someone comes to court and does not disclose a fact, isn't it my duty to bring it to your lordship's kind attention?
Okay, now do you intend to implead?
I can do that. We'll serve them. We'll implead.
In fact, my lords, on 5/11/24, if your
in all
lordship see the
fairness,
order,
they ought to have impleaded them in the writ petition.
They ought to have implemented them in the writ petition and said, in this proceeding, it has all come to an end, so that everyone comes to court and says, this is the situation. As an electrification company who's holding the bonds, I am not aware, my lord, of what proceedings are pending, other than what is placed before the court. Had, my lord, the regular first appeal and the pendency been placed before the court, I asked myself, could this order of release have been passed in his favor? It could never have been passed in his favor. Therefore, non-disclosure in my respectful submission is a material fact in this case, because I made a statement in court on the basis of the fact that the suit has come to an end and nothing else survives. And not disclosing that, my lord, in my humble submission, nothing.
Who are they?
Beg your pardon?
Who are those parties?
The parties, my lord, are, if your lordships kindly see the memo that I've given your lordships.
Somewhere they are reflected in this.
I've given a memo to your lordships today, my lord. One Rajaya has filed an appeal.
Yes.
The brother, my lord, of the person who passed away. The brother he died without a family. So siblings, where there is a rich relative.
REC is least concerned with that RFA.
Can't be. If you're
My friend has repeatedly made the submission that RFA was not known. Please see your lordship's order of 5/11/24 when my learned friends instructing counsel submitted that settlement talks are underway. What they intended was to settle the rate of interest with us, and in fact had a discussion on that. Now before your lordship, my friend has repeatedly made this submission that RFA, etc. That is completely besides the point. The obligation of REC arose in 2009 and the trial court permitted them to release the amount in 2009.
Page 7, my lord, of the appellants. There are, my lord, 3 appellants. We'll make them parties. We'll make the petitioners, appellants 1, 2, and 3 parties to these proceedings.
This is only to expand the scope of the dispute. Those appellants, if they are entitled,
I think, Lord, in all fairness, the petitioner must tell your lordships why they did not.
Let my friend not
RFA
interrupt me. Let my friend please not interrupt me. Those appellants, my lords, if they have any right, they will work it out in the appeal. If I have to pay to them in the appeal, I am answerable. They were not parties in the writ. They have nothing to do with this list. The principal amount has been released as I respectfully submitted. Permit me for repeating that. All that remains in this appeal on the pleading in the appeal is, my lords, whether interest should have been paid, which it should, because they have enjoyed the interest. They lend at 11%. The learned single judge has said pay 9%. And at what rate? That's the limited question before your lordships.
They were not necessary. They were not supposed to be party in the writ proceedings.
Please.
RFA was not filed until writ petition.
RFA was filed and thereafter the writ petition was filed. RFA was filed, my lord, on 23/8/2023. September 2023, they filed the writ petition. 7/9/23, they filed the writ petition. And my lord, it was admitted after hearing. Now, my lord, after all, and the final order is passed in 24. They had all that time to disclose to the court. RFA is pending, whether right or wrong, my lord. If the court had considered the RFA and then said, I'll still release, that is one thing. But the court was deliberately, my lord, not informed of the fact that there is an RFA pending. And that is the basis on which I made a submission to the court, that we have no objection then. If the proceeding has come to an end, please release the money, issues only of interest. But today we discover that they don't tell the court that an RFA is pending. And my lord, a person who has done something like this is now urging that I can take the money away.
Would my lords be pleased to see the prayer in the appeal, my lord, since my friend has repeatedly made this allegation without a pleading. Please come to page 19, my lords, in the writ appeal. Prayer is to set aside the order of the learned single judge insofar as direction to the appellant to pay interest at 9%.
I'm not asking for the money.
With due respect to my friend, there must be some, my lords, finality to the pleadings made in a writ appeal before your lordships on oath.
When there is no explanation as to why they have not placed the correct facts before the court, to argue pleadings, my lord, I would respectfully submit, is a little too far.
Having considered the subject matter of challenge. the impugned judgment and order of learned single judge, as well as the submissions made by learned senior counsel Mr. Dhyan Chindampa for the appellant as learned senior counsel Mr.
Aditya Sondi.
Aditya Sondi for the respondent. And in light of the contours of the controversy noticed, the board is of the view that private party, learned senior advocate for the appellant submitted that the private parties who have been agitating against the private respondents in the civil proceedings, in particularly the regular first appeal number 1674 of 23 and connected proceedings, are proper parties to be arraigned in the proceedings, in this appellate proceedings. It was submitted that these private persons ought to have been parties in the writ proceeding itself, since the writ proceedings came to be decided and the directions of payment of money, the respondent here given by the on a single judge, were in the background of pending RFA, in which the private parties had lodged the rival claims to receive the money on the maturity of the bonds in question. Full stop. The court at this stage is inclined to accept the submission. The private parties may be submission as the presence of those private parties would enable the court to take a wholesome view of the controversy. Full stop. In that view, the appellant is permitted to implead the private parties who are the parties to the civil proceeding. Full stop. Post title of the appeal shall be amended by carrying out such amendments. Once the post title is amended, there shall be notice to the said private parties returnable on 10th March.
The order be suspended.
Till earlier also. Let it be 10th. 28th February.
20th. Will this order be suspended till then, because there's a direction to pay interest now.
Let them deposit the interest before your lordships then, my lords. If my learned friend is seeking
There is an
any,
issue with respect to interest, and whether it's payable at all. In
therefore,
the
my
light of all
lords,
these civil proceedings, I think,
any
my lord,
stay on a direction or interest, let the appellant, my lords, make good that direction by depositing the amount before your
not
lordships.
like, my lord, we are a fly-by-night operator. We are a government company.
For 15 years, they have held the money with them, my lords. Please direct them to deposit the interest before your lordships.
Lord, money has been kept, my lord. As a matter of fact, the bond issue details that unless, my lord, a probate is given, I can't release the money. And it makes it very clear. And the bond issue conditions say there is no question of payment of any interest after the maturity date. Those are the grounds on which, my lord, the bonds have been issued in the first place. We are entitled to revisit to nominees. But if a person passes away, my lord, and there are civil proceedings pending, there has to be a probate. I'll show you, lordships, that clause itself in the bond, which has been ignored. Please come to, my lord, page 199.
The principal amount is already paid.
Principal and everything paid off. We paid the principal amount first. Issue was of interest. Had this RFA not been there, my lord, my submissions before your lordship would only have been on interest. But when we discovered the RFA, it is completely, my lord, misrepresentation to the court.
Lords,
And
the
not
pendency
linking the
of the
parties to the
RFA, as I
proceedings.
submitted, does not impact the REC in any way. The trial court never inhibited the release of this
These are-
amount, is what
These are
I meant
proceedings before a
to show
court,
your
the
lordships.
High Court, and such
This is a
conduct is
smoke
not of
screen.
parties.
This is not even their ground in the appeal, my lords.
I will now amend, my lord, my writ appeal to ask your lordships to
Now,
ask you to
by
redeposit the money.
bringing in, my lords, the private parties, what the REC is really doing is expanding the scope of the original writ petition. That was never the issue there. If a third party stakes a claim to an will or an amount, my lords,
The entire principal amount has been deposited in the bank and released to them on the basis of this order of the learned single judge, which order, my lord, was passed without knowing of the RFA. Had, my lord, that fact been placed before the single judge would have said, please implead them, because we must hear them before passing such an order. This was
lords,
nothing
REC
that was
doesn't
done,
hold
my
a
lord, with a
brief for some
single
third
intention.
party.
The intention was very clear. Don't disclose, take the money away as fast as possible. There was nothing more. And the executors, my lord, have taken the money. What they've done with it, nobody knows.
My lord, since my friend is repeatedly making this allegation without so much as a pleading, may I show your lordships an order passed by the trial court as far back as 2012, page 445. I think we all owe this to your lordships. Page 445 at 451. As far back as 2012, this is what, my lord, the court has held. 451, the last line. This, if I may read to your lordships, this court has concluded that the nominees are entitled to receive the amount from defendants 1 and 2, that is REC, which are due under the REC bonds. This court has not directed the amounts to be kept with any SB account of D1 and D2. In 2012, they had to release it to us.
Parties.
So REC is bound by this order.
At this stage, learned senior advocate for the respondent private party submitted that the appellant company should be directed to deposit the amount of interest on the bond amount. Full stop. In the context of the aforesaid request, the court notices the following operative directions passed by learned single judge in the impugned judgment and order. So page 46, bracketed portion 2, 3, and 4 will be 1, 2, 1 will become 1, 2, and 3. Paragraph. There is no dispute that the amount of rupees 7, 19, 66, 78, 718 contemplated in mentioned in direction number 1 has been released in favor of the original petitioners. Full stop. The second direction is about paying the interest, about liability to pay interest at the rate of 9%. Full stop. In the totality of facts, comma, it will be a balancing consideration between the parties if the appellant is directed to deposit the amount of interest. Full stop. Accordingly, the appellant shall, without prejudice to its rights, without prejudice to, without prejudice to the rights of either of the parties, shall deposit without prejudice to its rights, shall deposit the amount of interest before the next date.
Lordship,
With
may
the
carry
regi-
50% then.
With the registry of this.
Because even if the REC bond interest is taken into consideration, it was 5%. The REC bond was carrying interest at the rate of 5%. The learner single judge's order is not 9%. Or 12% if you don't pay it within 3 months.
So this person doesn't represent the percentage of the bond.
It doesn't even represent the percentage of the bond.
Represents the interest itself,
True, my lord. But
whatever context, but the interest in the context of bond.
Grateful to your lordship.
When you will deposit?
can it be at 5% then, my lord? I'll deposit at 5%, your lordship, in under 6 weeks' time. Because anyway, my lord, it's the government of India company. We are not going to go anywhere.
Deposit may be made, however, calculating the interest at the rate of 5%. Instead, the deposit of the interest shall be made before the next date of hearing at the rate of calculating the amount at the rate of amount of interest at the rate of 5% instead of 9%.
Yes. And Lord, your lordship may also direct them not to utilize those funds, my lord, because now there are so many other parties. And this is fraud paid on the court. By not
Lords,
disclosing
my
these funds.
friend, I take serious objection to fraud being repeatedly, my lords,
course. Is there
used
one
across the
explanation for
bar
why they
without
fraud?
an affidavit.
I'm
my
sorry,
lords,
there's nothing to say.
sorry.
It's on the face of it. Have you
REC
explained not
has
one
no say
explanation
on how, my
as to
lords,
why
the
they did not
principal
disclose
amount
to
is
the
to be
court
utilized.
of the RFA? Not one explanation. Why did they
Let
not tell
my
the
friend
court?
show you, that is for the RFA court to order, my lords, if
RFA
the
court?
RFA bench thinks,
This is my lord, unheard
as
of,
it is,
that a
my
party
friend has
comes and does not
expanded the
disclose the
scope of
fact to
this
the
appeal.
court.
And to allege fraud across the bar without a pleading more than once, my lords, does not behove, my friend.
I don't need a lecture from India. After not disclosing a material fact.
No, there is no question of withdrawal.
No, not withdrawal. The money, my lord, which they've already withdrawn, they'll have to account to the court. Because the money which was in the custody of the court, when they don't disclose that fact.
That is beyond the.
Precisely.
No, it is true, my lord, but I'm saying, if you, anyway, it's my duty to bring this fact to your lordships, my lord.
Even these directions are to an extent we are trying to go beyond the.
Yes, my lords, that
but
my
to
friend
see that
says.
the controversy is dissolved. Once the amount is deposited, the registry shall invest the same.
Yes,
Fixed deposits.
yes, that is.
With a nationalized bank, initially for 1 year, renewable, in a cumulative fixed deposit. Initially for every, but you will deposit, once you deposit, it will be,
Well,
no other day.
Grateful to your lordship.
Number 17, Mr. Vijay Kumar.
Notice was ordered on 4th of November 2024. Today we have the reply by the respond.
I am for the fifth respondent.
The order of the lower single judge is that Lord Annexure A, and the relevant is that Lord page 58.
clear
2
direction.
weeks time. I raised 2 weeks time. I am for the 5th respondent. Mandya Institute.
Though there was a specific direction, or the 5th respondent himself may not have committed, my lord, passed an order at Annexure F, page 115. But that itself shows, my lord,
Fifth respondent is private party.
No,
No,
Mandya Institute of
Dean
Medical
and
Science.
Director of the Mandya Institute of Medical Science. Annexure F, my lords, by which, my lords, we are made to approach this honorable court. Page
Direct.
115 minutes.
Dean of the,
Yes, ma'am.
Please.
Dean and Director of the Mandya Institute of Medical Science.
Governor Advocate Correspondent 5, time stand over 19th of, 20th of February.
Case number 18. Mr. Ajay Kumar Patil, party in person.
Party in person is not present, stand over 24th February.
Case number 19. Mr. Vasant Kumar HT.
For the complaint. Not the respondent accused has been given undertaking
may be
before
issued,
this
my
court that, my lord, he will pay, my lord, the arrears of permanent alimony of 12,80,000 on or before 20th November 24. Undertaking affidavit is also filed. My lord, a part of the amount of 2,80,000 has been paid, my lord, on 27/8.
Prior to
My lord,
filing the
I am
affidavit,
liable
he
to
is
pay,
making
my lord,
false
10,30,000.
I am seriously objecting for any extension of time, my lord. He is a chronicle defaulter.
One
He is
mo- one
not paid
moment.
any amount, my lord. Even after passing order by this
One-
lordship only.
One,
One second.
my lord, sir. The husband is, my lord, liable to pay, my lord, 10,30,000 balance amount on or before 20th November 2024, my lord. I have given undertaking, my lord, the money could not be mobilized. I am seeking indulgence that, my lord, the accused is agreed to pay 50% of 5 lakh, my lord, within 4 weeks and another 5 lakhs in
He is
4
a
weeks.
software engineer, my
Lord,
lord, is
I'm
drawing
taking,
1 lakh.
Only permit us to please consider what is.
I'm seeking, my lord, extension, my lord.
So you are
Parties.
liable to pay 12
10,
lakhs.
10,30,000, 2,80,000 has been paid on 27/8/20. Not even before, prior to that also 3,80,000 paid, my lord. May I
So-
request, my lord.
So 1080 remains.
10,30,000 I am liable to
In
pay.
six- Remaining 6 months, my lord, from the date of.
10,30,000, my lord, I will pay 30,000 today, my lord, 5 lakhs in 4 weeks and 5 lakhs in another 4 weeks.
Fair enough.
Madam,
He is saying
without any default, my lord, party is present.
Lord, the Honorable Division Bench is ordered to pay the entire arrears of on or before February 2024. He has not filed, for which the present contempt was filed. After filing the contempt, this lordship has an order to pay the entire dues within a period of 12 weeks. He has not paid. He has paid only 2,50,000, and this lordship has directed to file affidavit undertaking to pay the entire dues within a period of 12 weeks. He himself has filed an affidavit undertaking to pay the entire dues within 12 weeks, though he has not paid.
But this time, my lord, without any.
Because he's a software engineer, my lord, he is drawing 1,50,000 salaries.
Lord, his sister, my lord, husband died, my lord, their father-in-law died in the COVID, therefore, my lord, some difficulty. This time without any default, lordship pay, my lord. I'm seeking extension. Lord, I have sought for
extension
8
cannot
weeks, but
be-
your lordship may kindly record my submission that, my lord, out of 10,30,000, today I will pay 30,000, 5 lakhs in 4 weeks and 5 lakhs in.
Lord, without committing any default, he will undertake to pay the entire dues on or before 20th of November. He himself filed affidavit before this lordship only, without committing any default.
Lord, this time you'll.
Simply only to trouble the complainant, my lord, he is making false submission.
This time, my lord,
He's
not even a
financially
single day
sound.
will be defaulted.
He's financially sound, he's a software engineer, drawing 1,50,000 salary. Based on that salary, the the monthly maintenance was granted for rupees 40,000 per month. Only warrant may be issued, arrest the person. Unless, otherwise he will not pay any.
Once you pay the amount, the matter will be over.
Pardon?
Once you pay the amount, the
My lord,
execution petition is pending before the trial court where, my lord, I have raised an objection regarding her disqualification that she got married. My lord, inquiry is held and matter is reserved for orders. My lord, if the court holds against me, I am liable, they can recover it before the execution. This is only limited to the dismissal of the MFA, where MFA court will order to pay amount till February. But I have paid here up to August, my lord, till the date of your lordship's passing order. They can very much recover in the execution petition which is pending before the, my lord, executive.
No, he filed an affid, memo for close the execution petition as the contempt is pending before the lordship.
No, execution petition
I'll
is pending.
I'll produce the memo. He himself filed the memo before the execution petition for closing the execution petition.
Per month you are paying,
40,000 rupees.
you are paying,
Please, my lord, that I am liable to pay, my lord.
you are paying or not?
Lord, so far I have paid, my lord, I have mentioned that 6,60,000 rupees
That is prior
has
to
been
before-
paid.
That is area.
prior to order.
You are regularly paying or not?
No, my lord.
Lord, since the order has been passed and I undertook to pay the amount, my lord, therefore I have paid accordance with the, my lord, orders of this.
That deals with two aspects, payment of 40,000 every month and the
Please.
arrears to February 24.
Please, my lord.
So from onwards 24 February 2024, are you paying 40,000 every month or?
No, every month I am not paying because since, my lord, the amount has been quantified and, my lord, I am directed to, I undertook to, my lord, pay the,
It is quantified up to February 24.
Yes.
no, my lord, August 24. August 24. Your lordship may kindly peruse the order dated 20th August 2024. Your lordship has passed an order that the calculation at page number 2, my lord, as on the date of the passing of the order by this honorable court. This is up to 22/8/24. Page number 2 of your lordship order on 28/24.
Impugned order passed with the division bench, page 24 may kindly be seen.
Page number 2 of your lordship's, my lord, orders. My lord, out of this, my lord, lordship may kindly see already, my lord, 6,60,000 has been paid already.
It is not the order up to August.
No, page number 2, your lordship may kindly see, page number 2,
Impugned order
22,
passed with-
calculation from 23/21 to
Kindly be seen.
22/8/24.
Ink page 29.
Please,
My lord, the impugned order.
Lord,
page
my
40,
only-
24
Lord,
may
my
kindly be
only-
seen, my lord. The division bench has ordered to pay the maintenance for rupees 40,000 every month till the month of February 2024.
no, this time, my lord, I will not, my lord.
Yes, not, but hence the present contempt was.
On my bona fides also, my lord, by paying
No, no bona fide at all, madam.
6,30,000 already paid.
In light of the directions of the division bench in miscellaneous appeal number 3231 of 2021 to pay the amount of maintenance and arrears, this court by passing order dated 20th/8/24 observed after note of the amount calculated that up to August, up to 22/8/24. So even thereafter you have to pay, ne?
Please, my lord, I am liable to, Lord, they have already execution is
After
pending.
August, Lord, he
My lord,
has
my
not paid it.
only, my only difficulty is,
The total amount of maintenance payable would be supposed to be 16,60,000, out of which the balance required to be paid. Balance which was not paid was 12,80,000. At that juncture, learned error of the respondent stated that the said amount will be paid. Respondent response stated that the said amount will be paid within 12 weeks. $250,000 is paid or not?
please, 2,50,000 plus, my lord, 3,80,000,
That is paid.
6,60,000 already paid, lord. 6,30,000.
Thereafter, the court passed direction in the said order dated 20th/8/2008/24, requiring the respondent to pay rupees 2,50,000 within 1 week, and further directing the respondent to file affidavit about his commitment
to pay the remainder amount. Paragraph. Today when the contempt petition comes up for consideration, a memo came to be filed by the respondent husband, in which it is stated that due to the pressing circumstances, the husband could deposit 3,80,000.
10,30,000 I am liable to pay. Today, my lord, I will pay 30,000.
As on
In
date-
4 weeks, I will pay for 5 lakhs
As
and
on
another
date,
4 weeks, I will pay 5
14,000.
lakhs.
14 lakhs as on date.
Deposited, that deposited 2,50,000 as directed, and in addition rupees 3,80,000. It was submitted that due to pressing circumstances, the balance amount of 10,30,000 could not be deposited. He
Please.
further, learned advocate further submitted that out of the said 10,30,000, rupees 30,000 is being paid
Today only.
today
Please.
to the petitioner wife. It was requested that for rest of the 10 lakhs, 2 installments be given.
My lord, 5 lakhs within 4 weeks and 5 lakhs within 4 weeks.
That the amount shall be paid. That amount may be permitted to be made, permitted to be paid. That the amount may be permitted to be paid in 2 installments at the interval of 4 weeks each.
Please, 4 weeks.
2 months. 4 weeks, 1 installment, another 4 weeks, another 2 months. Yes, asking.
We are not granting. We are granting 2 interval of 4 weeks each.
Yes.
Full
2
stop.
months.
In the facts of the case, the request is granted. The petition shall come up next on 27th February, on which date the respondent shall report the compliance about payment of first installment of rupees 5 lakhs.
Much. Please,
To be listed at 2:30, only for that purpose.
please. Much.
December 20, Mohan Kumar Reddy. December 20,
Keep back. That party in person may also be kept back, 18 and 20, so that he may not feel that. First. Yes.
December 21, to Chandrasekhar Vai, the party in person.
Party. He is not party in person. Party in person. That's how. Infectious. It is against metro project. Review. What is it? It will not survive.
Please not serve.
Copy not so. Keep back. Put.
December 22, Abhinay.
Yes, please, sir. This is a writ appeal arising out of a single bench order wherein the constitutional validity of demanding advance pro rata charges was been upheld. Challenges as present writ appeal is filed.
Delay is condoned or not condoned?
Delay is not condoned. Notice has to be gone. There's one memo filed along with the appeal.
IA 1 of 24, this IA is filed, this application is filed seeking to condone the delay of 60 days, which has taken place in filing of the appeal. Paragraph, the accompanying affidavit spells out the reasons leading to So reasons for passage of time leading to delay. In the text of the case, sufficient cause is made out to condone the delay to the extent of 60 days. Delay is condoned, application is allowed.
Notice may have to go, my lord.
Notice is not gone.
My lord, respondent number 3 to 5, notice may have to go, my lord.
Then notice will go. sir.
1 and 2 I accept.
Returnable on 25th March.
Please, please. Okay, standing counsel may be
Office
served.
objection shall be removed before next.
One of the office objection, have complied, Your Honor. I had filed a memo, the non-filing of statement of objections filed by respondent number 3 and 4.
If not complied.
23, 24 are urgent, serial number 25. The Shankarappa, serial number 25.
Keep it.
Petitioner, not counsel, asked me to request this honorable court week's time to file affidavit, not petitioner's counsel.
You are for respondent.
I am for the petitioner's counsel, not appearing on behalf of petitioner
Why?
counsel.
Very
Who asked me to request this honorable court notice week's time
Why?
for filing affidavit notice. His client is not well, it seems not.
Client is
His client is not well, it seems not.
not well.
Twenty-five not serial number.
Paul Malott, he appears for the Chief Executive Officer, Zilla Panchayat.
Misuse of MPMLA fund.
Yes, my lord, 2 crores 17 lakhs. Misused by respondent number 6. Who is the respondent number 6? His particulars are not forthcoming. It just says the Panchayat Development Officer.
Will not give further time. When shall we? When do you want?
Next week.
Next,
1 week, my lord, he asked me to take.
to be listed on 4th of February at 2:30.
Applied.
With an observation that no further time will be given to either of the party.
26.
Since the petition belongs to the year 2019.
26 is urgent, serial number 27. HP Leela.
Say the affidavit to us, I will file it to your us. 2 weeks may be granted, filing affidavit to us. What happened the first time that matter has come? When the petition has been filed, that it was not been implemented.
My lord, this petition pertains to removal, demolition of a building which is constructed in violation of the bylaws. My lord, I have received a communication from the Chief Officer, Town Municipal Council. My lord, I'll place it with a memo, but this is the original, my lord, letter saying that there are no violations. Given on 17/2/2020.
You have filed some counter, not now.
No. My lord, I'll file this with a memo, my lord.
4th February. To be listed at 4th February at 2:30 in order to enable learned additional government advocate Srimati Neela Parak to file a counter oblique memo, comma, as it is the submission on her part that she has received the letter from the chief officer of the town municipal council giving instructions relating to the subject matter grievance.
Much of.
Obliged, my lord.
Shri Yadunandan Yan.
Please, my lord. Objection has been raised that, my lord, to be accompanied with affidavit, my lord, came up for the first time. This objection, my lord, I'll have to comply. I need some time. Comply.
The present petition filed, styling it as public interest petition, and the petitioner projecting himself as vigilant person, vigilant and public spirited person. Advances prayer to direct response number 1 to 5 authorities to preserve and maintain the land described as land survey number 23 capital A at measuring 1 acre and 26 guntas, 91 square yards.
Lord, I'm sorry. What
Situated,
accommodation will be granted, my lord? Senior counsel has been engaged in the matter, at least maybe passed over, my lord.
situated at Prashant Colony, Vidyanagar, Hubli, Dharwad district. The case in nutshell sought to be pleaded that the land in question is notified and earmarked in the comprehensive development plan showing the same purpose of the land use. It is the allegation that the land is not appropriately maintained to subserve the purpose. Is not approved maintained. And that there is an illegal collusion. There is a collusion among the landowners and the authorities. Today, the petition paragraph comes up for removal of office objections. Therefore, it is evidently indicated that the public interest petitioner, after filing of the petition 6 years back in the 2019, has not cared to take any steps to remove the office objections.
My lord, I'm sorry,
Full stop.
it came up for the first time today, my lord. This office objection is pointed
The
today.
interest petition sat tight and took no interest in prosecuting the petition for long 6 years. Full stop. This very aspect, when the petitioner is negligent towards the alleged public cause and has not taken any steps and has remained inactive since 2019 and never took interest in seeing that the petition is taken up for consideration, the petitioner is not entitled to prosecute the petition, projecting himself as public interest petition.
My lord,
This ground alone, the petition is dismissed.
kindly allow me to submit, my lord. My lord, this objection has been
Authorities,
raised for the-
however, look into the subject matter to
Please, my lord, this objection.
determine that the land in question is put to use
Yes, my lord, third party interest has been created.
in accordance with the
Lord,
earmarcation.
Area reserved
Yeah,
for
yeah.
open spaces and civic amenities, they're using. to
Don't do
construct
for
buildings,
6
my lord.
years to sit tight and all of a sudden come.
No, my lord, I have been moving it, my lord, I have come on NOC, my lord. Before that, my lord, it had come, the matter was listed several times and objections have been filed by respondents, my lord. This objection of affidavit, today for the first time, my lord, it says, today for the first time it is raised after 5 years, my lord.
To file counter.
My lord, the admissions are enough, my lord, to dismiss the writ petition. Admissions in the writ petition are sufficient to dismiss the writ petition.
What admission?
My lord, that this area that had been reserved for park has now been sold, my lord, and a third party interest has been created. My lord will get it at paragraphs, my lord, 5 to 7.
Paragraph?
5,
5.
5, 6, and 7. Clear admission?
Kindly it may be passed over, my lord. Senior counsel will argue the matter, my lord. It's been engaged. Request. Lord, annexure A might be looked at, my lord, 28, the layout plan. Annexure A, my lord. There, my lord, the first says open space, which is given URS number, my lord. Now there, they have issued CTS numbers by the municipality, and my lord, now they are trying to sell that land, which is reserved for open spaces, my lord. That's the very litigation, my lord.
Sale deeds have also been produced, my lord.
Lord.
Paragraph 6. My lord, the concerned authorities have failed to take possession
That
of
would
the
go
land
against you.
earmarked.
Could go against. While the above is the position obtained before last paragraph. Learned additional government advocate Sri Nilofer Akbar submitted that on the showing of the petitioner himself, the land in question has been sold out
Yeah.
for the purpose of sold out in favor of respondent 7. And the sale deed is also executed.
Yeah.
Full stop. According to her submission, this aspect is enough for not entertaining the public interest petition. Full stop. While taking note of the said aspect, it is observed that the respondent authorities shall look into the subject matter, and if an irregularity is committed with regard to the land use, appropriate steps in.
My lord, they themselves have sold this, my lord. The respondent
Respondent
themselves
number
have,
3 has
they
to take
themselves have
action
sold
when-
this. That's the very problem, my lord, which is reserved
Respondent
for
number
civic.
3 has to take action. It's Hubli Dharwad Municipal Corporation. But since they contend, my lord may take the first sentence in paragraph 7. Since the respondent number 6 has sold the land which is meant for the purpose of civic amenity,
Yes,
third party interest has been created, and my lord,
that may not be a good argument. On the contrary, it will go against if the land
meant for
civic amenity is sold by a private party to another private party.
it's a Hubli Dharwad Municipal Corporation.
While the petitioner has admitted the above aspect in his pleading, there is no corresponding prayer in the petition. In that view also, the petition is not liable to be entertained. Full stop. In any view, the petition is dismissed on the aforesaid ground with an observation, with a qualifying observation that the competent authority of the respondent shall take appropriate steps if an irregularity is found. Appropriate steps in accordance with law if any irregularity is found. Dismissed as above.
No, my lord, may I make a submission? My lord, various representations have been made, my lord. I'll place everything on record, my lord. My lord, civic amenities being sold to, my lord, public, my lord. We have no other way, my lord. We have approached every authority, my lord. Every authority we have raised a complaint. All those complaints are pending, my lord. None of them have returned with an endorsement, nothing, my lord. All those representations are there, my lord. I'll place them on record.
You enter the courtroom after 6 years and we entertain the PI.
My lord, 2019 onwards, my lord, order sheet.
You file a petition in 2019.
Please, my lord.
Effectively enter the courtroom to argue the matter in 2014. You did not remove the office of this. And you want us to entertain the petition?
My lord.
That to PIL. And are you a vigilant public interest petitioner?
Lord.
Who's in slumber for 6 years?
Lord,
Sorry.
My respectful submission, my lord. All office objections were cured, my lord. This is the first time it has come up, my lord.
No.
My lord, order sheet
29.
seen, my lord. This is the first ever time that objection has come up, my lord. And from 2019,
Very fact that this is kept pending for 19 is a good enough ground.
We have been present, my lord. My lord, they have sought, respondent have sought time many times to file objections, my lord. The authority which has sold the site
And then we
have
have
sought time to file objections. They have now filed objections, my lord. Now, my lord, finally it has come up for hearing only because after many times they sought objections.
Even otherwise, you have dealt with the subject matter on merits.
But 29. Saravana.
Yes. Why it is pending since 2019?
My lord, I'm for respondent 4 and 5.
The respondent, what is the subject matter? Remove the encroachment made on public roads.
my lord, the town concerned, town municipal council has not been made a party, my lord.
Is not a made a part.
No,
Deputy Commissioner, Bangalore.
Deputy Commissioner District, my lord, but this thing is by the town municipal council. My lord, by now, I think the Kendra must have been constructed and must be functional also.
What is constructed?
My lord, Rajiv Gandhi Seva Kendra by the Gram Panchayat.
Allotted for establishing Rajiv Gandhi Seva.
Yes. My lord, could I just take instructions and make my submissions, my lord?
4th February,
Yeah, that's fine.
to be listed at on 4th February at 2:30.
Flash.
Yeah, Ravi. So name of the counsel who is on record shall be indicated while notifying the petition on the next.
Number 30. Mr. Chandranath Arikake.
May I please your lordship? My lord, what is questioned in this is, one is the inaction on the part of the municipality to take action against the respondent number 2.
Lord, before that, one submission on. I appear for the respondent number 2, my lord, party has taken no objection from me, my lord. 2 days back, they have not filed wakalat, fresh wakalat. I appear for respondent number 2 earlier.
I would also request 3 days, my lord. I would also request 3 days.
Heard learned advocate Mr. So and so for the petitioner, learned additional government advocate.
My lord, we are not a party then, my lord.
Municipality.
Municipality is a-
So what about the order passed on 22/12/20 regarding police protection to demolish the construction? What happened?
Like, building was not demolished, not,
No,
they have not demolished. the building.
demolished.
Not demolished.
No,
So it was found to be regular.
please,
No,
that municipality has to say. No.
municipality
But-
itself.
I am for the private party, respondent number 2, my lord.
So you produced the completion certificate of the building obtained
that.
from the.
Party has taken NOC wakalat from me, my lord. 2 days back, party has taken file along with NOC wakalat. Lord, they might have.
The learned advocate so and so appears on behalf of respondent number 2 to submit that he has filed wakalat number 2 days back and is.
No, my lord, I have issued NOC 2 days back.
You issued NOC.
Please, issued NOC, my lord. They have not filed a fresh one. They have not engaged any other advocate. I have.
No, you will not permit you to retire. This is public interest petition. You take instructions.
They have taken
No,
entire.
you
file.
can't take disadvantage of the proceedings by changing the advocates in a petition pending since 5 years. And burden the board and the.
I'll instruct the party. I'll instruct the party once again. They have taken back the file. Once again, I'll kindly have next week, my lord. By then, my lord, I'll make some arrangements.
The petition was filed in the year 2020, alleging that the construction of the building is illegal. The construction was undertaken by respondent 2, the private respondent 2 herein. Today, when the petition comes up for consideration, after a long time, learned advocate Mr. So-and-so for respondent 2 stated that he no more has instruction to appear and the papers are taken away from him by the private respondent number 2. Full stop. In that view, there shall be notice paragraph to private respondent 2, returnable on 27th February, within which time the private respondent shall appear before the, within which time the private respondent number 2 shall make necessary arrangement to engage an advocate or appear in person before the court to answer the case of the petitioner, answer the controversy. Full stop. Paragraph. While passing the aforesaid order, the court notices order dated 22/12/2020, passed by the court, reading as under.
Please, much obliged.
On the returnable on the next date, respondent 2 shall produce the completion certificate in respect to the building constructed, which may have been issued by the city municipal council or town municipal council, whatever. By the town municipality.
Please.
Certifying that the building is in accordance with law.
Yes.
And according to the construction bylaws.
Yes. So office objections matter, seal number 31 for third time. Mr. Gaurav GK.
So 4 weeks time is granted to remove the office objections, failing which the appeal shall stand dismissed without reference to or order of court. Next.
For fourth time, seal number 32.
Same order.
Hearing for appellant, my lord.
Same order. Remove within 4, otherwise will be dismissed. Next.
33.
Same order.
Complied, my lords, have been directed to verify. I've already complied, my lords, have been directed to verify.
Complied with
I've complied this morning itself. It may be directed to verify, my lords.
all that.
Sorry,
Learned advocate Miss
Marsha, M-A-R-S-H-A.
stated, for the appellant stated that the office objections are complied with.
Yes.
The registry shall verify the compliance, and if the objections are complied with, shall list the appeal on 18th of February for admission here.
Yes.
Number 34. For fourth time.
Same order. We grant 4 weeks time.
35.
My lords, 35, I may be permitted to withdraw the petition, my lords.
No, what is that? PIL we don't readily permit to withdraw.
My lord, it is infructuous, my lord. It has become infructuous.
Let us see.
My lord, the matter was with regard to installation of some shops in only month of Ramadan, my lord. Since the entire month matter could not listed, my lord, it has become infructuous, my lord. No other prayer, my lord. No other prayer.
Learned advocate for the petitioner states that the subject matter of this petition has been infructuous, as the shops are permitted to be established.
Please,
Shops
Lord.
are why
My lord,
it is infructuous?
voluntarily they withdrawn, my lord. All shop owners voluntarily they withdrawn, my lord. My suit became my petition became infructuous, my lord.
What is withdrawn?
My lord, there are no shops on the footpaths, my lord. It's only for the month of Ramzan, my lord, that they
So
have infractions. It was for last year.
Dismissed recording.
Please, my lord.
Is number 36.
Appear for the respondent, my lord.
I've complied with the objections, my lord. 36.2 and 36.3, my lord. Complied with the objection, my lords. I just have to make one submission, my lords, regarding one objection, my lords. In the impugned order, my lords, my name is not reflected. Lordship will see page number 26, my lords. I've complied with all the objections, my lord.
Earlier some order is passed.
Yes, my lord.
Right.
Order dated 24th October 2024. Ma.
Lord, on 24/10, your lordship had said the learned single judge had quashed the acquisition. But the metro said that they require about 12 guntas of land, for which we agreed.
Yes.
Now, I have handed over possession to them. Only thing is, Lord, they will have to give me compensation. For that, Lord, I am requesting whatever compensation paid to the adjacent landowner, let them pay it to me. I will execute a sale deed in their favor. I have handed over possession to them because they needed the land urgently. I am filing a memo to that effect also.
Expressly submitted to the learned single, kindly see at page 36.
No, I have said, kindly see, Lord, I am filing a memo. I made a submission that whatever package offered to others, if it is given, I will hand over. That is what I am saying now. May I just pass on this memo, Lord? Adjacent landowner Shantala Enterprises, they have given compensation. Let them give me the same compensation.
After having made a submission, now they probably become.
No, I am not.
We want a higher amount.
No.
Made a solemn undertaking.
And I am sorry. Kindly see my statement, Lord. My statement in the learned single judge's order. They don't want it to take that money, they can hand over, I mean, I'll retain the property.
Make a solemn undertaking to the learned single.
No, undertaking is what I am referring to. My undertaking is whatever amount is paid to the others, same amount should be paid to me. That is what I am saying. Now, without paying compensation, how do I hand over the property to them? If they are not interested, they can leave it at that. The page 36 of the appeal papers.
The impugned judgment, paragraph 15, running page number 36. Paragraph 15, 1-5.
13 of petition.
Of the
Judgment, my lord. Learned single judgment. My lord. Learned single judgment.
para 15 and 16 of the single judge's judgment.
The learned senior counsel on instruction from petition number 2 who is present in court submits that in respect of the portion of the lands belonging to petitioner number 1 and 2 have been earmarked for the use by BMRCL, and he submits that the petitioner ready to hand over this land provided package compensation offered by BMRCL is offered to them. So the word is package compensation. My lord.
That compensation is what I am seeking.
17, and the learned counsel for BMRCL submits the compensation amount in respect of the lands needed for BMRCL has been deposited with the KIDB. If the KIDB is prepared to pay the said package amount to the petitioner, the statement of the petitioner that they would hand over possession of the land which is earmarked to BMRCL is placed on record. Pursuant to which your lordship was pleased to pass an order, my lord, directing us to give the money, the package compensation which has BMRCL has given us to give the money. We have issued notice to them, they have not come.
No.
Deposit the
They
money
have
before
not-
your lordship.
Lord, this package which they are referring to, Lord, the land came to be acquired in 2002. No award came to be passed. Court has held that the acquisition is abandoned. Now in 2020, Metro has come forward saying that they need the land. Now they are trying to offer me compensation in 2002. What I am saying is adjacent land, Shantala has been given the compensation. Same amount you give it to me. I am not asking for anything else. Let them consider and say whether it is permissible or not. Otherwise, my lord, we will have to. Under this memo, my lord, adjacent land in 2020, they cannot give me compensation in 2002, value of the land prevailing in 2002. 2020 compensation is given to Shantala Enterprises in 2020.
that amount I am also entitled to. Now they are referring to some package, my lord, which is prevalent in somewhere about 20 years ago.
We are not referring to what they
No, you
want.
are referring to that package only.
What?
When was the preliminary notification?
Preliminary 2002.
Preliminary notification.
2004 final notification.
2002.
No award is passed till now. Single judge held that the proceedings are abandoned. Now I have succeeded before the single judge. In writ appeal, because airport
25/11/2002.
One second. Airport metro is going. I said, I convinced my client, all right, you give the land to them because it's a matter of public interest. Provided 2020 is what the metro is wanted deposited money before KADB. So 2020 they paid compensation to Shantala Enterprise, adjacent land. I am saying that give me the same compensation.
No, originally the land was sought to be acquired for what purpose?
For industrial purpose,
Industrial
general
purpose,
purpose,
my lord.
not for metro.
Not for metro, my lord.
No,
What's the case?
Metro requirement came when?
2020.
20, my lord.
Now, this writ appeal pertains to what?
Please, my lord.
Now, this
A
writ appeal
portion of
pertains
the land, my lord, with the
12.
KDB has given 12 guntas of land, which the KDB has given to BMRCL for the purpose of metro from Hebal to the airport.
Let them give me the value in 2020, my lord. I have no difficulty. Even if I go back.
this is being agitated by BMRCL and not by KDB as such, which had issued the initial preliminary notification.
Absolutely, my lord. Your lordship, sir. Correct, my lord.
You can-
Ultimately,
So, the requirement for BMRCL, when did it come?
2020.
2020, my lord.
Meeting held in 2023 where the price was fixed and the package compensation was offered. I would respectfully submit this. The petitioners, the original writ petitioners, were aware of the amount, the package compensation.
What is that package?
Correct. That's
That
20 crore 31 lakhs 34,000.
And
That
what
is their package. That is
what-
not my understanding.
What is the amount paid to the adjacent owner?
Is about
19,000.
19,000 per square feet. 19,000 per square feet is the amount given to the adjacent owner in 2020.
What it totals come to what?
It comes to for about
29 crore.
Can I place that on record?
24 crores.
No, we just wanted to.
no, just
Only purpose of this.
understanding the difference amount. Understand,
No other purpose.
understand.
If something can be found out.
Instruction on what is it. But my only submission is.
But the package compensation is a statement
No,
made
this
by you.
package
yes.
package compensation, if they give me, I'm ready
It was
to.
it was you who accepted the.
I
Proposal
expected,
for
my lord, the
payment.
compensation which is paid in 2020 to the adjacent land. No, they think that package refers to 2002.
No, we are saying that statement was by you, that
By me, because,
provided
what-
the package compensation is offered to.
yeah, the compensation package,
To them.
I
So it is
understand.
his statement.
I stand by that statement, but that package should refer to what is.
Package compensation is interpreted as adjacent land compensation.
It's 2002, what happened? No, that's fine.
Full copy.
Right. The 2020 value ಕೊಡಿ ಅಂತ ಕೇಳೋಣ.
ಹೌದು ಸರ್, ಇಲ್ಲ ಇದೆ ಸರ್. ಅದು ಬೇರೆ ರೀತಿ
ಬೇರೆ ಪಾಯಿಂಟ್ ಬಿಡಿ.
We postponed the date of. See, recently in Nice matter,
Please, Manoj.
Supreme Court came up with a judgment wherein the compensation,
Postponing the date of.
And Chandrasekhar, I think you were there in the judgment delivered by me that
I think
sitting
that
for.
your lordships are referring to that
Can you make
Bernard
one
Francis
request, ma'am?
Joseph.
Make one
Identical.
request.
Where I said, because it was acquired for the purposes of railways, upheld the acquisition, but postponed the date of preliminary
That is what
notification.
Can you make one
will come
request?
to you.
As the lordship are pleased to point out, the question is, what is the quantum of compensation, whether package amount or the adjacent land?
Not
No,
package amount prevailing in
No,
2020.
No, I'm not, your lordship may kindly see whether it's a package amount, what as stated in paragraph 15, or the adjacent land as a memo sought to be filed. We'll, whatever the package amount, without prejudice, Manoj, will deposit the money, let them withdraw without prejudice. The lordship will decide then the only what is the, in this facts and circumstances, the date has to be transferred or the adjacent land should be given, will be the question. Let the project, just one sentence, let the project go on, Manoj. That's all I'm
No,
requesting.
project will
Because
go on.
just
No, project will go on because yesterday itself I handed over possession without receiving a single paisa. But the question here is, my lord, now 2002 onwards, the acquisition proceedings are going on, nothing has progressed. Now what I am requesting is, give me value as on 2020, that is all, without going into any of the other issues.
Now that has to be decided.
correct. That is all.
This
Till
is in
then,
respect of 12 guntas only. Remaining other extent land, but your lordship can decide. But now to asking me to hand over position without making any payment, my lord, would cause me a lot of hardship. Now they have paid, my lord, in 2020 only for adjacent landowners. Now for 12 guntas only we are concerned, not in respect of the 1 acre. 1 acre, your lordship can decide it later. Because of the urgency pleaded by them, we said, all right, we will hand over. Now to say that they will give me 12 crores, which was prevalent in 2002, my lord, it will cause a lot of heartburn.
one submission.
Lord, what I would request is let them
One
examine it.
submission.
If there is any some kind of a solution which could be arrived at, then we will see.
But when the learned advocate general is making a very fair proposal that you withdraw at least that amount, which is undisputed, or a package amount.
Lord, that is of 2002 value they are giving me.
Manoj,
2002 value.
Pending the things consideration further.
yes,
Lord, what I
with
would
prejudice to
request
his rights.
what I would request is let the advocate general conduct a mediation. I will see what can be done and
Then go for mediation.
You're open to it, Manoj.
Advocate general himself can mediate. Allah, Advocate general himself can mediate.
No.
ಏನೇ ಮಾಡು. Can arrive at.
That is the better thing.
If Advocate general intervenes, my lord, we can find some solution.
Sometimes courts are better mediator than anybody else.
In fact, if
So
Mr. Arnold itself is there, we can sit and sort it out.
I have faith in the advocate general doing some.
So we will get the figure of the package compensation and the amount paid to the adjacent owner. And we
Because
we
we
again
did not want to,
put to you that you can withdraw the amount of package compensation.
we did not want to prove
This to your rights.
Lord, we made this statement because we did not want to pose
no.
any obstacle.
You can withdraw which is the deposit.
Let us see, my lord, we'll try to work out something. Because I made this statement thinking that as a member of public, I should not come in the way of this metro. Otherwise,
Possession was handed over yesterday.
Position 14. Photo in any other contest. The dispute which finally surfaces in this writ appeal is about the entitlement of respondent. Original petitioners to receive the compensation payable against utilization of their land for the purpose of, it is metro rail, metro rail project. Paragraph. After considering the limited controversy, when the following order was passed on 24/10/24 by the court, whom it appeared that the dispute was on the road of resolution. Paragraph. The relevant part of the order and observation read as under. So court paragraph 3.1 onwards till 6.1. Today when the proceedings came in for consideration, paragraph. Learned Advocate General Mr. K. Shashikiran Shetty stated that the amount of compensation is already released and stands deposited.
No, we have issued notice, they have not taken it, permit us to deposit.
No amount is paid till now.
They have not taken, I am ready to give today itself.
Stated that the notice is already issued to the original petitioner to receive the amount of compensation, which is a package compensation,
Which is disputed.
which amount is payable, according to learned Advocate General, in light of what is observed in paragraph 15 of the judgment and order of learned single judge.
That is my
Learned,
statement.
Senior Advocate Mr. So-and-so, so-and-so, the original petitioner, however, stated today that the petitioner is not inclined to accept the package compensation.
Package, inclined to accept package amount as it prevails in
However,
2020.
However, the petitioner is ready to accept the amount of compensation equivalent to what is paid to the adjoining owner. Full stop. At this stage, learned Advocate General submitted that the package amount of compensation which the authorities are ready to pay may be accepted by the petitioner, original petitioner, subject to further consideration and without prejudice.
That may not be required.
Without prejudice to the rights and contents of the parties. Full stop. However, this proposal is not acceded to by the petitioner, and that the senior counsel has stated that the petitioner will not accept the amount. Full stop. It was stated that the possession of the land is already handed over to the authorities yesterday. Full stop. Paragraph. Stand over to. When with you after 2 weeks? 20th, 13th February.
Please.
On which date? The
Matter could be considered for mediation.
on which date, comma, learned advocate for the respondent shall made available to the court, make available to the court the details the amount which is payable under the package compensation as well as the amount which is paid to the adjoining owner.
Now, what I thought was, if some solution could be worked out in mediation, it could be done. Otherwise, once again, we are back to square one.
If you are agreeable for some midway amount, then this can be put an end to.
No, that will not causes lot. Now, if they say, I'll pay the amount which is prevailing in 2002, how is it, how can they say that? Let them say they will, whatever may be the value, deposit the value as it prevails in 2020. That is what is done by the Supreme Court in several cases.
Then it go for me.
Metro came into existence in 2020 only.
You also come with some proposals, if it is possible. Please. On that day it is not worked out, then we'll send to mediation.
Can I make one request, my lords? There's a package compensation, there's a adjacent land one compensation. Let them give a proposal to BMRCL, ultimately who have to pay. Let them consider place that also.
Lordship will permit me to place the proposal.
Place the proposal to them. Can I make?
In the meantime, in the meantime, as requested, the petitioner may put up a proposal.
Please.
Petitioner,
Before-
respond
before the-
125.
BMRCL.
BMR,
Writ petition.
Bengaluru Metro Rail Corporation Limited regarding the
Payment of compensation.
payment of compensation. Original petition, everywhere original petition.
Please.
Yes, mediation.
When it is 13th February.
Serial number 37, non-compliance of office objection for 5th time.
Week's time may be. Week's time may be then for. Half of
For
the.
5th time, so we'll give 3 weeks time, failing which same order.
This is number 38, Mr. Vardhaman V. Gunjal.
Hearing for petitioner, my lord, 1 week time may be given, I'll do the needful.
As prayed for by learned advocate, so and so, so and so. 1 week time is given to remove the office objections. Dealing with this public interest petition shall stand dismissed without reference to a order of the court on the ground of non-removal of office.
Is for 6 times, number 39.
My lords, I am appealing for the 6th respondent, my lords. The 6th respondent has died, my lords. The PIL has.
What is it?
Register may be directed to show the name of Sharvana, my lord. Serial number 39, my lord. In that, D.R. Ravishankar sir is there, my lord.
Let us see. 5 years old
Senior counsel.
petition. The order is already passed in 2021. So how this is for office objects?
My lords, 6th respondent, my lords. He died, my lords.
Who is 6th respondent?
He is a license holder, my lords.
He is license holder.
Please, my lords.
Who has put up the construction?
My lords,
Who has put up the construction?
they say like that, my lords, but it is already shifted to some other place, my lords. Not in that particular place. It has been already shifted to some other place. After the death, my lords, the license has been transferred in the legal heirs name, my lords. So they have already shifted, my lords.
This petition needs immediate disposal accordingly. Who is number 6? Who has died?
My lord, 6 is the person who has unauthorizedly constructed
That
the
is what
shop.
we are asking, yes.
Yes. And respondent number 7 has shifted his CL9 license into this unauthorized construction. So the first prayer is to demolish the unauthorized building. That Mr. Somayaji has to make a submission, my lord.
So what do you say, Mr. Counsel, for the petition? What do you say?
My lord, an adjournment, my lord, and register may be directed to show the name of Sharavan, my lord. Sharavana.
Whose name?
Register Sharavana is my lord.
Learned
It is showing the name of.
stated that the name of the counsel for the petitioner, Mr. So and so is not indicated on the board. The registry shall mention the name of the learned counsel while notifying the petition next to be listed next on 19th February, before which date it is further provided, that it is further provided that for which date learned advocate for this one 6
Please,
shall take necessary steps.
My lord, the petitioner has to take,
They have to take the.
Petitioner shall necessary.
my lord, a shorter date, Mr. Somayaji can apprise my lords what has happened.
Because they have already shifted, my lords. They are not in that particular placement.
Not in that.
No, my lords. License has been shifted to some other placement.
There are 2 prayers, my lord. One is to demolish the unauthorized construction. The other is opposing the shifting. So
But you take the instructions in light of the order which was passed on 8/12/2020.
8/12?
2020. The stand of the state government, as can be seen from the statement of the sent, is that verification is not required of law.
My lord, after the shifting is, order is passed, my lord, this couldn't have been.
But then
Anyway.
licensing aspect may be over, but whether the construction is regular or irregular, it is also remains.
My lord, that the respondent number 5 will have to make a submission. The panchayat.
Who appears?
Mr. Somayaji is not present.
Mr. BJ Somayaji.
So we'll keep it on 4th February.
Very well.
4th Feb-
Tentatively, my lord.
4th Feb. To be listed at 2:30.
Please, my lords.
This seal number 40, office objection for 7th time.
Each time may be granted to rectify the office objection.
2 weeks' time.
Please.
Is granted, failing which same order. Granted for removal of office, failing which petition shall stand dismissed without reference to our order.
This
Yes.
office objection with submission, seal number 41. Selena Abraham, 14%.
With submission, my lord, parting person, my lord. My lord, this is a contempt petition I have filed. So the respondent is my husband, my lord. He has come for a settlement, my lord. In that, based on the settlement terms, and there was a judgment order passed, my lord, which was happened in Kerala, page number 34 to 35, my lord. So my divorce petition was disposed based on the settlement terms, my lord. So the settlement terms copy also I have filed, and the order sheet is in page number 36, my lord. And notarized translated copy also I have furnished here, page number 42, my lord. In that page number 42, serial number 5 of the settlement conditions, my lord. The respondent agreed that he will withdraw case number OS 2892/2022 City Civil and Sessions Court and divorce case MC 209/2022 filed in the Family Court, Bengaluru, and certified copy of the said order will be handed over to the petitioner on the day of the statement taking. So he has agreed that, my lord, but against that, he has not withdrawn the same petition, he has not filed for a joint divorce petition. Maliciously, he is continuing the same case now. So kindly, contempt can be initiated against the respondent.
Where is the order or the compromise?
The order the judge has mentioned, order is page number 33 to 34, my lord.
So what is the direct, what is you are alleging contempt in respect of which part?
The settlement condition translated copy I have filed, my lord. That's page number 42, my lord.
42.
42, 42.
It is no. It is only a memo petition, I think, 42.
Settlement before principal counselor.
So 21 order of which date?
Judgment order in 2023, my lord. That was.
Page 58.
It was in 2023, my lord, because I was a party in person, I was not aware. So what I did was I filed in MC 209. In his divorce petition, I have filed the contempt petition, my lord. So kindly see the judgment order sheet in the MC 209, my lord. In that page number 69, my lord. The order dated 24/7/2023. So in his petition on this particular date, page number 69, order dated 24/7/2023. I have submitted before the Honorable Judge Family Court, and I have filed one IA, that is IA number 10. Respondent filed application under section 11 and 12 of Contempt of Court Act, IA number 10, and application under section 10 of CPC, read with order 2, order 7, rule 11 of CPC. So my hope was that, my lord, the family court will take the contempt proceedings. But while receiving, the Honorable Judge also denied this matter. And after 1 year, my lord, the order dated 8/7/2024, my lord, the page number 75 to 76 of the same order sheet, my
Which
lord.
is the order under contempt according to you?
Order under, it will come like both, my lord, because Kerala court he came and he has,
No.
he told he will withdraw the case in Bengaluru, my lord.
It is not.
And Bengaluru court also, I told the same thing. But when I filed a contempt petition before the Bengaluru family court judge, that my contempt application in the same petition, my husband's divorce petition, was kept pending for 1 year, my lord. After 1 year, asked me to file a not press memo telling that there is no jurisdiction. So then I found out, my lord, only High Court has the jurisdiction. Then I approached the High Court, my lord. So only on 20.
Respondent has withdrew the case number 2892 or not? City Civil Court.
Both the cases there are contempt, my lord.
Withdrawn?
No, my lord. Both the cases are
Going on.
Going on, my lord.
So
That is why I filed 2 petitions, my lord. 2 contempt applications.
Why 2 petitions?
Because one is running in family court case and another one is in city civil court. 1188 is in city civil court.
You need not file 2 contempt petitions.
I did not know, my lord. Later I came to know. Apologies, my lord.
So who will appeal? Rest matter?
No, there is delay. Then there is a question of maintainability is there. Maintainability, I mean, she's not telling which is the order that the respondent has gone to contempt of. Which is the order which he has not obeyed? Which is the order that is under contempt?
Kerala,
Settlement before principal counselor, is it?
my lord, based on that settlement, the judge has passed an order. Kerala family court. The order kindly see, my lord, page number 33 to 34. settlement, the counselor will take the settlement, but the settlement is filed in the same case, my lord. The heading of the settlement is mentioned, so and so case. And this settlement,
So
based
co-
on the settlement only, the order has been passed.
Court has passed order in terms of settlement.
Yes, my lord.
Where is that order?
Page number 33 to 34, I shall read the judgment order, my lord. Taken today, matter is settled between the parties and decided to file joint petition for divorce. Hence, accepting the compromise, this OP is dismissed. So, based on that, my divorce petition itself is being disposed, dismissed, my lord.
No, but this is not Karnataka, so this is Kerala court.
Divorce is given or not given?
Not given, my lord. 5 years I am fighting before the court, my lord. And I am the first woman in the world, my lord. I am fighting 3 petitions, my lord, for getting a single annulment of marriage. I am made to file, I am made to fight, my.
Kerala?
Yeah, it's Kerala.
This family court at Pathanama,
Pathanamthitta.
where?
Kerala, my lord. My lord, yeah, in that, he came and he told he will withdraw the cases which is running in Bangalore. Is the parties are same, no, my lord?
Then the contempt, we have to go before the Kerala.
My lord, now Kerala court is telling they don't have jurisdiction because the case which he told to withdraw, that is in Bangalore. That jurisdiction will come Bangalore High Court. The 2 cases which he told he will withdraw, those 2 are running in Bangalore, my lord. Here the Honorable Court has the jurisdiction. And my lord, one more humble submission, have a small minor child also. Now we have relocated in Bengaluru past, after 2000, from 2023. We are now staying here. She is going to school here only.
Child is with you.
Yes, my lord. 7-year-old child, she goes to Sacred Heart High School here only. So it won't be possible for me to now, because being a single parent, I'm overburdened, my lord. I'm fighting my own cases. And because of this, around 30 cases, my lord, I had to fight. My husband is earning 4 lakhs, my lord, per month. Till now, single penny is not even awarded any maintenance also, my lord. We are almost made to start to death.
Pardon?
We are made to start to death, my lord. I'm not working, I'm a student.
That is correct, but we'll provide you the assistance of some legal aid counsel.
My lord, initially in Kerala, both the places I got cheated kind of with the counselor. So I'm very scared now even to approach the counsel. So Kerala, what happened is that my counsel, she has changed the entire petition. She, like in case 1 CR, I asked an alimony, she changed it into 5 lakh. My false sign has been put. And all these things I came to know after 5 months. And moreover, now 5 years I'm fighting, my lord. From 2021 is my first filing of the divorce petition. And there is a nullity also in our marriage. He is an important and
we
had
don't-
the child through donors for IVF treatment.
You understand, please, madam, we don't have the jurisdiction, we can't help you. That is the whole. In Karnataka, we can't have the contempt jurisdiction for, in respect of the order passed by the Kerala court. That is whole thing. Only lawyer can,
My lord, but he told he will withdraw so and so petition.
Only lawyer
It's
can-
running in Bengaluru.
only lawyer can persuade you. Judges have no persuasive capacity.
My lord.
So what you decide for yourself, what to do. We can at the best, at the most rather, adjourn the petition. Or we provide the legal aid counsel.
My lord, when I asked some lawyers in Kerala also, And they told these two cases are running in Bengaluru. They are telling I cannot file in Kerala. So because the cases which he told he will withdraw, that those cases are running in Bengaluru, my lord. My lord, if there is a divorce happens in one state, another state also it is valid, my lord. So kindly in that way, kindly consider this matter, my lord.
Having heard part in person for some time and having apprised ourselves about the controversy and the nature of the contempt petition, the court feels that the part in person deserves to be provided legal assistance. Therefore, the Secretary, Karnataka High Court Legal Aid Committee is directed to provide a legal aid advocate to the party in person, Srimati Leena Abraham. Full stop. The contempt petition shall next come up on 19th of February. Full stop. The registry is directed to intimate about this order to the High Court Legal Aid Committee. Nothing more we can do.
My lord, how I will go to Kerala and fight now, my lord? He a single parent.
We'll see once the lawyer asks. At least the lawyer can assist the court, if not you. Come on to next. Come on, which date it is? 19th February. 42 also same?
42.
40.
Same, my lord. That is one in city civil court case, one in
So
family. court.
42 stand over to 19th February to be listed with contempt petition number 1123 of 20.
Number 43. Chandranath Agole.
Respondents.
Office objection with counsel submission.
I'll appear for the appellant, my lords. The office objection is with respect to the not making the respondent number 5 as a party in the writ appeal, my lords. The respondent number 5 is Mugambikai Charitable Education Trust, which runs the Rajarajeshwari College of Engineering, my lords. Since only the aggrieved party preferred an writ appeal, my lords, so the charitable trust may not be a necessary party to the writ appeal.
Pardon?
My lords, the office objection is with respect to the not making a respondent number 5 as a party to the writ appeal, my lords. The respondent number 5 is Mugabigai Charitable Education Trust, my lords.
He was party in the main proceeding.
They were party in the writ petition.
And you have to arraign him. All parties who are arraigned in the original proceeding of petition are required to be made parties in the appellate proceeding. Therefore, the objections regarding non-joining of respondent 5 in this appeal could be said to be proper. The appellant shall comply with the office objection by making necessary amend the cause title, joining said respondent 5. Within 2 weeks, the appeal thereafter shall be listed on 12th, on 14th February.
Yes, ma'am.
Read.
Number 44. Shrikara Peke.
This is regarding an extra seal not being legible. Only the annexure seal is not legible, my lords. I request for the office objection to be overruled. It's an annexure to the writ petition.
Not legible.
Only the annexure seal is not legible, my lords, is the objection.
Pardon?
Annexure seal is not legible. Yeah, I just request for that to be overruled. my
You
lords.
will argue only on the basis of an exercise.
It's an I'll file a type copy. There's no harm.
Will comply with.
I'll comply.
Learned advocate so and so states that the objection regarding the type copy of the annexure shall be complied within 2 weeks. The petition thereafter may be listed for admission, appeal there may be listed for admission on 17th February,
The previous matter was on 18th February. It's the
18th
same
Feb-
subject matter.
18th February.
This number 45. Mr. Nityananda Nayak.
For the appellants regarding the furnishing translated copies of the annexures. I furnish the same within a week. In the meantime.
45. Translated copy of delay also
Yes,
there.
Notice.
So translated copy of all annexes in Kannada to be furnished.
I will furnish within a week. In the meantime,
Within
within a week, I will, in the meantime,
Honorary
notice may kindly be.
is permitted to remove the office of residence within 2 weeks. After the office is removed, the appeal may be listed for admission hearing on 19th February.
May request the notice on the IM allotment.
No, before you remove, how can it?
Yes. Only thing, the definition of the family is required to be considered.
Upon you remove the office of. If you are giving today the translation, we can do.
Relying of the 2001 government order, which is in English, my lord. That provide for, doesn't provide for the definition of the family.
On
Definition
that
of-
day will consider. You file the translation.
I- 1 week time.
1 week,
Up to a week,
all right,
no?
1 week time. And list it on 6th of February.
Number 46.
Appearing for the leading respondent.
Matter relates to selection in the Karnataka Power Corporation Limited. Issues with relation to negative marking. It's the learned single judge, my lord.
How come you-
Manoj, I appear for the respondent, the Karnataka Power Corporation, Manoj. Manoj, may I request for a date any date after the 28th, Manoj?
Pardon?
May I request for a date after the 28th, Manoj?
After 28th.
Please.
And if the IA for impleading could be allowed, my lord, because even we are candidates in the selection process conducted by KPCL. So if the IA for impleading could be allowed.
20th February.
There's an oral understanding that they will not precipitate that mind.
Manoj, not precipitate, it's only no appointment orders will be issued, that we will.
Better, it is better that.
Kindly,
Then-
Manoj.
Grateful.
Great.
Kindly, Manoj, sir. Seal number 52, Manoj, sir.
Passover matter, seal number 21. Mr. Chandrasekhar Bhai, the party in person.
Party in person was absent in the first half as well as in the second session. The petition was called out twice. It could have been dismissed for want of prosecution. Or in the larger interest of justice, turned out to 20th February. Not 4 times, not remaining. To be listed at 2:30, the party in person shall be intimated by the registry about the next date of posting.
Number 47.
47, my lord, state appeal, my lord. The office objection is that the color photographs in annexure C
Office
series have to
objections
be
are dispensed with. However, the black and white photos will be produced.
that have been produced, my lord. The office objection is that color
Office
photographs.
objection is dispensed. Next,
This silver-
appeal may be listed in the same matter. Office objection regarding color photograph is dispensed with. The appeal may be listed for admission hearing on 28th of February.
Great.
Number 48.
I appear for the appellant in this case, my lords. My lords, the office objection is with regard to paragraph number 16 to 19 of the writ petition not being produced by me. My lords, I have produced the writ petition copy as served upon me, my lords. So that office objection may kindly be overruled for the time. I will apply for a fresh copy of the writ petition and produce the same.
No, you apply and produce. Office objection shall be removed within 3 weeks, telling which the appeal shall stand dismissed automatically without reference to the order of.
May I request notice upon the respondent number 1, my lords?
No. You have
I
to
may
pro-
be permitted to take it on the counsel who appeared for the writ
You have to
petition.
produce the entire pleadings, complete pleadings of the petition.
I produced everything except that one page because it was served on me like that, my lords. I've produced the copy of the writ petition as served
If it is
upon.
not served on you, when you file appeal, you must get the copy, complete copy and produce, yes.
Number
Very well.
49
So I
is
will
adjourned.
file.
Number 50. Mr. Narayan Bhatia.
I appear for the respondent, my lord.
Number 50.
These are a series of appeals which have been filed, wherein the gratuity authority order which was stayed and quashed by the learned single judge has been stayed by in one writ petition. So what has happened is the gratuity authority's order has become an enforceable order. Thereby, the writ appeal itself has been allowed by virtue of the stay granted. So that is my predicament, my lord.
I have one submission to make.
But then what about this?
I have one submission, my lord. The question involved, the two legal questions are involved in this case. 50 and 51. Whether controlling authority under Payment of Gratuity Act has power to adjudicate upon the deduction of income tax on gratuity, that is TDS. Assuming the authority has jurisdiction, whether the authority can direct the employer to refund the tax which has already been deposited and remitted to the income tax way back in the year 2012. These are the two legal questions. There are 48 writ petitions, my lord. Writ appeals. All are identical matter. Whatever we argue for one case, the same argument will hold good for all the other cases. All the time now requesting your lordship says, your lordship may, I will furnish the list to the court officer. Your lordship may kindly have all those matters during second week of February, my lord, so that we will address.
Give number.
We will furnish the list tomorrow.
Give number.
Tomorrow. We have been served copies. We have been
Get it listed on 18th of February.
Because within 10 minutes I will argue.
Yes. 18th of February,
I was.
all matters.
ED.
In a separate,
Posting, memo for.
I will finish the list
in a
because
separate.
they have served us the copies. I will furnish the list tomorrow morning, my lord.
Appeared for
appellant.
Office objections are, office objection is with regard to the translation, they have to comply with. We complete.
That may be required well, because that is the foundation of the order. Controlling authorities order, it requests to be translated.
Shall be complied with.
If it is done in one case, that is sufficient. Identical order.
Meanwhile, I will complete the.
Bill number 52. With the Sarojini Mukherjee.
Getting a synopsis in a couple of minutes, but till then, now this is a case where primarily, my lord, we need to understand that there were two different cadres of employment with the appellant organization.
How many appeals? Three appeals.
Three appeals.
Three
Notes
petitions.
common or two writ petitions. Common order was passed. Notes first petition was insofar as notes my promotion from the cadre of notes flight test engineer 2 to 3 and 4 respectively. The second one was notes as the amount which was being paid as the pension from my naval services was sought to be deducted. However, was provided in the case of others, I preferred another writ petition. Common order was passed. First petition was allowed in my favor. However, as I wanted some the benefits to be modified, I have preferred one writ appeal. They have challenged the order in entirety. The writ petition, second writ petition, as it is dismissed, I have preferred the other.
So two writ petitions and three appeals arising. One being a cross appeal. Including one cross appeal, there are totally three appeals. Not the appellant, I'm appearing in, my appeal is 1348 of 2024. But in this, there are two appellants. The first appeal is, the first appellant is the Union of India by the Department of Research and Development. Under this body, there is another society which was formed called as the Aeronautical Development Agency. The primary object of this society was to conduct research in aeronautical sciences and particularly to help India develop its own light commercial aircraft. And one of the first tasks that was given and which is being handled by the ADA is the light commercial aircraft called Tejas. Light combat aircraft called Tejas. Now, the combat aircrafts, they have dual use. One for the Navy, it will have to land and take off from a carrier. And for the Air Force, it can fly off from a land. Therefore, there were two facilities which were developed. One in Goa called as the shore-based facility, which would simulate as though there was a ramp which would simulate as though the aircraft can land and take off from the carrier. And there was also a body called as National Flight Testing Center, which would draw pilots from the Air Force, the HAL, and the ADA itself. This would contain a pool of about 10 flight test engineers. The job of the flight test engineer is to ensure that the aircraft is ready to fly. The pilot will come and fly it off, but the job of the engineer is to ensure that everything is fine and it can fly. Now, as far as the facts are concerned, the contesting, there is only one respondent in my case. The respondent was an officer with the Navy. He was working with the Navy. He had qualifications to discharge his duty as a flight test engineer. During 2008 and 11, he was attached to the office of the appellant ADA. He was attached. He was not deputed, but he was attached. So during the attachment, he worked in the premise at the ADA, but then he continued to draw salary from his employee, which is the Navy. In 2011,
the appellant ADA called for recruitment to various posts. And one such post was called as the scientist F. Now the scientist F does desk job. And the parameters required for that particular job was I can't read this. Okay. So item number 2 in the advertisement that we issued was for the flight test engineer. The qualifications required were engineering and management. If I may read scientist F, it says engineering graduate with MBA. The essential requirements was minimum 12 years experience in project management, in large project in the government, autonomous, public, private sector, including in the areas of project planning, scheduling, coordination, monitoring, reporting, using computer-based project management tools, should have good analytical and presentation skills, experience in aeronautical industry preferred, desirable, ME, MTech, and relevant discipline. So your lordship will notice that none of this would match anything required to, with the flight test engineering. This was all about scheduling and management and project management. Nevertheless, the respondent applied for this particular post, that is scientist F post, and he attended the interview, and he was successful, and he was no, I've got the synopsis. Let me just pass. If your lordship would now kindly see the synopsis. On 3/7/2008, Commander so-and-so, who was the respondent before this honorable court, was an employee of the establishment strength of Indian Navy, who was posted to the Aeronautical Development Agency, appellant number 2, on attachment basis, drawing his salary and other allowances from Indian Navy. He was on air engineering duties to help out in light combat aircraft project meant for Indian Navy. It was developed by the ADA for the Indian Navy. And 25/5/2010, the ADA issued an advertisement number so-and-so inviting application for various posts of scientist and engineering category, specifically prescribing therein the pay scale and the qualification criteria. 27/5/2020, respondent applied for the post of scientist engineer F so-and-so. And then please have a look at that in the next page, the essentials of that particular job description. Minimum 13 years of experience in project management, in large projects in the government, autonomous, public, private sector industries in the areas of, Lordship would kindly note the areas, project planning, scheduling, coordination, monitoring, reporting, etc., using computer-based technology, and should have good analytical and presentation skills, and experience in the aeronautical industry is preferred. So nowhere it refers to air engineering. The scientist stuff does not deal with the air engineering at all. And then on 19/1/2011, the respondent appeared for the personal interview at the Recruitment and Assessment Center conducted on behalf of ADA for the post of scientist. Upon being selected by the interview committee, the respondent was issued with the offer of appointment on 19/1/2011 for the post of scientist staff. It was also sent to so-and-so. Para C in the terms and conditions of the offer of appointment clearly details out the pay to which the respondent shall be eligible to avail upon him joining ADA as scientist staff in the event of his release from Naval Headquarters on his premature retirement. Therein it is stated that the respondent's pay on joining ADA will be fixed as is applicable to re-employed pensioners as per provisions contained in DOPT official memorandum dated 31/7/1986 as amended from time to time. Lord, this would be a contentious issue. On this point, the learned single judge has held in my favor. He has followed this official memorandum and held that the salary refixation will be on the basis of this particular memorandum as a re-employed pensioner. Then on 22/2011, the respondent wrote an acknowledgement letter to ADA, consciously accepting the offer of appointment along with the terms of his pay stated therein. So, which means he accepted the terms of payment. 23/3/2011 to 28/4/2011, upon premature retirement, respondent was relieved of his services in Indian Navy by letter dated so-and-so. And my lord, the next date is crucial. 29/4/2011, respondent was appointed as Scientist Engineer F for the program activities of LCA Navy, Department of ADA, for which he submitted an application voluntarily. The respondent underwent a process of selection before he was appointed to the post of Scientist F. Therefore, his posting from Indian Navy to ADA was not on deputation and absorption. Rather, he is considered as re-employed on the grounds of him opting for a premature retirement from his service at Indian Navy. In terms of the recruitment policy, he cannot continue his service as commander at ADA. He was appointed as Scientist F through open advertisement and selection by a duly constituted selection committee by RAC, which is a nodal agency for recruitment and assessment of scientists and technical personnel of DRDO and AD. On 23/5/2011, pending receipt of pension pay order, PPO, the pay of the respondent was provisionally fixed based on his last pay slip for the month of March 2011. While fixing the pay, the estimated pension of respondent was taken at rupees 31,360 and his basic pay was deducted to adjust to the pay band of 21,350 along with grade pay of 8,900. Now, this is also one of the contentious issues, which is why I have reproduced. So effectively, by following the rules, we deducted his pension and refixed his pay. Then 31/5, the Office of the Comptroller of Defense Accounts issued to the respondent his pension pay order. And on 27/6/2011, on receipt of the PPO, the pay of the respondent after adjusting pension was fixed with effect from 31/1/2014 by office order dated 27/6/2011. In terms of the DOPT order, the pension granted to the respondent by Indian Navy was deducted from his basic pay. This is in compliance with the rules governing the pay fixation for re-employed pensioners. This point also the learned single judge has held in our favor. He has held that such deduction is permissible. In the light of para 4D.
Notes to cut short. Great respects. Lord, that argument was advanced.
No, I'm sorry.
Only insofar as
please make
reduction
notes.
of pension.
Please make notes.
I know.
But I would like to read.
It is my appeal, my lords, which needs to be argued.
Please don't interfere. Please don't interfere. In para 4D of and 1 of the aforesaid, if I'm wrong, you can point out when you get your turn. D and I of the aforesaid DOPT order, basic pay of the respondents joining ADA as Scientist F was fixed at rupees 48,710, along with grade pay of 8,900. Out of the basic pay so fixed, rupees 27,355 was deducted towards non-ignorable component of the pension. Then 25/7/2012, respondent continued to receive the pay so fixed from the date of his joining until 25/7/2012, on which day, for the first time, he made a written representation raising an issue pertaining to his pay scale. By receiving the pay minus the pension for 15 months, the respondent, my lord, this is my submission, that the respondent had impliedly acquiesced with the terms of offer for his appointment at ADA. Then, my lord, in September 2013, respondent made a representation dated 13/9/2012 to ADA for considering him to be appointed as FTE. So, my lord, this is very crucial. So what he does is, in September 2012, although his appointment was for as scientist F, he says, I have the qualifications, treat me as having been appointed as the flight test engineer. And we give a response to it. 9/7/2013, the appellants denied to consider the respondent's request dated 13/9 with the following observation. A, nature of work, pay scale, allowances payable to the scientist and FT are totally different. Would your lordship, Justice Emerald, has the copy of the?
Go on with your thing.
No, I thought I have handed over. If I have handed over.
We have the copy.
The case of appointing and posting and FT for LCA Navy had been examined and informed that there is no need for such a post. And see, as and when there is advertisement for the post of FT, the officer may apply for the same. And D, there was no advertisement issued by ADA inviting application for the post of FTA at NFTC. So somewhere in 2012, when the respondent claimed that why don't you treat me as FT, we wrote back and said we never called for any FT at that point of time. We advertised for scientist F engineer. The nature of work is totally different. We appointed you for the post of scientist F. So therefore, you are a scientist F, not FT.
FT is fire test engineer.
No, it is flight test engineer.
Nice.
Flight test engineer.
So it is a question of from promotion FT 2 to 3.
So he was appointed as scientist F engineer on 29/4/2011.
Issue is about the eligibility and entitlement of promotion from FTE 2 to FTE 3.
No, first is from which day he is treated to has been appointed as FT. Learned Single Judge says, though he was appointed as scientist F, in 2014, we converted it. In 2014, there was a need for a FTE. We converted his appointment from scientist F to FTE. That was a conscious conversion. There was a post created. Based on the requirement, we converted.
Yeah.
The previous payment minus pension. So, then he is given the scientist. But later on, that is converted to flight test engineer. So it is everything has to be supported by the document.
Date which on the date of his conversion, not that part is critical. Would your lordship kindly turn to in the list of dates that I have given, 22/11/2013, in the list of dates that I have given, 22. That would be, I'm sorry, there's no pagination, but 22/11 is the date. 22/11/2013. If your lordships got it or not. The Standing Committee for the Governing Body of ADA sanctioned 2 FTE and 2 FTP posts on the regular strength of ADA to be posted at National Flight Testing Center. Out of the 4 posts, 1 vacancy was utilized to convert and redesignate the respondent as FTE. Now, this is very critical. There was the pursuant to permission granted, 4 posts were created, and one of the posts of FTE, instead of advertising and calling for, since the respondent had the ability, he had the experience, we decided to convert his particular post from scientist F engineer to FT. Now, 31/1/2014 date is crucial. Pursuant to the approval of the Standing Committee of the Governing Body of ADA, an office order dated 31/1/2014 was issued, redesignating the respondent's post as flight test engineer FTE2. Accordingly, the respondent was required to assume the charge in the changed cadre of FTE2 only on 31/1/2014 and not from 29/4/2011, as he was not performing any flight testing activities between the period 29/4/2011 and 31/1/2014. Lord, this argument of mine is very, very critical. So what I'm contending is He was appointed as scientist F on 29/4/2011. Until we converted the post to that of FTE on 31/1/2014, the respondent did not discharge any duties as FTE2. He was not discharging any air engineering duties at all. So his air engineering duties commenced only upon his appointing as the FTE2. Not on the second unnumbered para. I will take the photo. The redesignation of the respondent from scientist F to FTE2 was approved to assist the LCA Navy program towards requirement from shore-based test facilities at Goa with full financial benefits admissible to ADA FTA with effect only from the date of his assumption. But here I must also point out that the flight test engineer gets a higher remuneration. That is because there is some sort of an ordeal. It is not within a confined area. He has to be outside. There is some amount of risk involved. So the emoluments are much higher. So there are specific emoluments which are payable, which I will take your lordship through. And then on, my lord, please now look at the next page, 31/1/2014. Respondent wrote a letter to the appellants assuming the charge in the redesignated post of FTE2 with effect from 29/4/2011, the date on which he was appointed as FT engineer instead of 31/1/2014. 25/4/2014, the Joint Director ADA issued a reply to the aforesaid letter of the respondent communicating that the proposal for converting the appointment of the respondent from scientist F to FTE2 came into effect only from 31/1/2014. He was also directed to submit a fresh joining report indicating the date of assumption of charge of FTE2 as on 31/1/2014. And in the meantime, my lord, there was one development that took place. My lord, please turn to 1/8/2017. The appellant issued a letter inviting respondent to submit a revised PPO for the implementation of the 7th Pay Commission. In this regard, neither a reply was received from respondent nor he submitted the documents. Additionally, appellant ADA made several attempts by writing to the pay office to forward the revised pension order. And then Lord 310, Lord, this is a very crucial date, 3/10/2017. The National Flight Testing Center ADA issued a confidential report on the respondent by a report dated by a report number so and so. And Lord, I'll take your lordship through that. But if your lordship will see the essence of it, which I have captured under the date of 3/10/2017, it says qualification other than the basic entry level qualification, officer does not possess any additional qualification. Flight testing experience, the officer does not possess adequate flight test experience. Several claims made by the officer regarding his flight test experience are assessed as inflated or irrelevant. Poor attitude demonstrated by the officer in his assigned duties in the SPTS has led to PDFT specifically requesting his removal from all tasks. And when it comes to unique skills and qualifications, the observation is officer does not possess any unique skills qualifications which could justify overlooking other adverse factors. Specifically, the officer does not possess a basic understanding of carrier suitability, flight testing, and design activities. The officer has overstated his contribution in some design related activities, whereas in others he demonstrated capability is unsatisfactory for an FT. Potential for integration into NFTC. Posting of the officer to NFTC would be unacceptable, disruptive, and a flight safety hazard. So this was the report submitted. Finally, in 2019, when he completed 5 years of residency period, he was due for promotion and he was called for an interview because the promotion and recruitment rules requires formation of a committee. He was called for the interview, and in the interview, he did not fare well. I will produce copies of the confidential seats, and therefore he was not promoted. When he was not promoted, that is when he approached the learned single judge. Before the single judge, please have a look at the prayer that the writ petitioner sought. Lord, page in my writ appeal, it is page 117. Page 117 in the writ appeal is the relief sought. Before that, my lord, would your lordship please have a look at page 298, because that's the impugned decision. Page 298 is annexure AAH dated 20th May 2020.
page 298.
This is in 9687. This writ petition, what you are referring to is 9687.
1 minute, I'll confirm it. Is that the WP 9687? Yes.
Where is 9688?
We have not checked. It's not part of this writ appeal. It is produced.
If you have the copy of the writ petition, we'd like to have a look at the prayers.
No,
Lords, I have challenged the.
May I do this? First, I will read the prayer in 9687, then I will read the prayer in the other.
Now, we would like to have a look at it, 9688.
Yes, I will do that. But since I am arguing on 9687, please allow me to read 9687 first.
We'll permit you, we'll have a look at that prayer and then go ahead.
Your Worship, sir, having my lords, my writ appeal, particularly my lords, 1848.
I will read it.
No,
I will read
What
it.
is-
Court wanted to have a look at the prayer in the other petition.
Yes, I will read it. Yavudu, first volume ali idea adu?
First volume,
Okay. It is in WA 1842,
48.
1848 hours. 1848. In that, the writ petition prayer is at page number 45. I'm sorry. Page number 117. In WA 1848,
So this 1848, 1348.
1848.
184. So two petitions were filed.
The WP 9688 begins at page 99. It begins at page 99 in WP 1848. The prayer can be seen at page 117.
See, counsel, in other words, your submission is, number one, you are serving in the Navy. Then he was attached to you. Thereafter, you called for, what is that? Scientist F.
Scientist F. Yes, we called for
Now-
recruitment for the post of scientist F.
You recruit him for that particular post.
Yes,
You cannot now turn around and say he was not qualified for that.
that is what the petitioner says.
Whatever, you cannot turn around and say he was not qualified that. You made that submission. You made that submission in your arguments. You said you took us through the qualifications required for that particular post and said he does not have it.
No, I never said that.
Yes, you said it just
That's
now.
not what I said. I'm sorry. I said, please look at the qualifications for that post. Because he was eligible, we have appointed him.
Okay.
Maybe there is some mistake in how
You
have
have,
understood.
okay, you have appointed him for scientist F
Yes,
post.
because he satisfied the qualification
Yes,
for that.
there you are required to show the letter of appointment and the contract of employment, in other words. Because usually in these circumstances, there will be two methods in which they will be appointed. Number one, he submits his resignation or takes voluntary retirement from Navy
Yes,
and he joins you afresh, where you appoint him without any conditions. Or
no. we
on
appointed-
certain, without any conditions insofar as his claim in respect of the Navy is concerned. Or in the second instance, usually it will be salary minus the pension.
That is law. We have followed the law.
You are required to show it, the terms of employment. The terms, what the terms of employment say so.
So we'll come to that. In fact, no, Lord,
Then after that, you designate him as an FTE.
on the points that the learned single judge has held in my favor, I do not propose to enter upon that now. I have challenged the learned single judge's order of allowing his promotion. In this writ appeal, I'll confine to that. That is for my learned friend to order because he has suffered an order.
It is for him to point out that how learned single judge is wrong. I will defend. Once he argues, I will defend. Which is why I said, allow me to read the prayer in the petition which I have challenged.
Fine, go ahead.
The learned single judge has rejected the second writ petition which he had filed, has dismissed it.
Thereafter, you appoint him as an FTE 2.
When your lordship says thereafter, what does it mean? After what time?
After scientist F,
Yes.
after some time, you appoint him as FTE
In
2.
2011, he was appointed as scientist error. In 2014, we converted it to FTE.
That particular document you'll have to take us through.
Yes, yes. Please, for that, would your lordship kindly have a look at the conversion document, conversion approval, which I have produced at page number 251 in my appeal. Page number 251 is the order of conversion. It runs into about 3 pages. Let me read the operative part at page 253. Approval of the item 11. Approval of standing committee of governing body of ADA is sought for converting appointment of Commodore so-and-so, scientist F, as flight test engineer against existing governing body approved vacancy with full financial benefits as per existing rule as admissible to ADA. And then the appointment. Okay. Now kindly turn to the order of redesignation at page number 259. This is the actual order of appointment. Page number 259, marked as annexure AH. It's titled as redesignation of scientist engineer F to flight test engineer 2. Pursuant to the approval of the standing committee.
What is important over here is you read approval sort that clarifies so many things.
Yes. Para 11. No, which para does your lordship want me to read?
Para 11.
Para 11, I read once, if I can read it again.
One second.
Page 253.
Yes, read it.
Approval of standing committee of governing body of ADA is sought for converting the appointment of so-and-so, scientist F, as flight test engineer FTE against existing governing body approved vacancy with full benefits as per existing rules as admissible to ADA FTEs. So there is no dispute about it. What we are saying is we have sought for approval for converting the respondent from scientist F to FTE as against an existing vacancy at that point of time.
See, it does not speak about with effect from.
No.
So should we presume that is appointment?
For that, please look at the appointment order. Please look at the appointment order at page number 259.
Page?
259. In the very same volume, just a couple of pages ahead. 6 pages ahead. 259, 259.
59.
This is the order of appointment. Office order. Redesignation of scientist engineer F to flight test engineer 2. Pursuant to the approval of the standing committee of the governing body of ADA, vide so-and-so dated 22nd November 2013, which I just now read, so-and-so is redesignated as flight test engineer in the pay band of so-and-so with effect from the date of assumption of duty as FTE2. So it will have only prospective effect. From the date he assumes duty as FTE2. We do not say from the date of 29/4/2011. Because for us, there are two different cadres altogether. Lord, please also have a look at the next para, my lord, that's relevant. Based on the approval of the standing committee of the governing body of ADA, so-and-so is entitled to draw the following special allowances as FTE2 with effect from the date of his assumptions of duties as FTE2. Permit me to read the different titles of payment. Flying pay, 30,000 per month. Hazardous flying pay, 26,000 per month, FT allowance, 15,000 per month, flying kit maintenance allowance, 10,000 per month, pre-flight meal allowance, 4,000 per working day. Now, why would I pay all this to a scientist staff engineer who is doing scheduling and monitoring sitting in an AC chamber? So these are all allowances payable only to a flight test engineer who assumes duties and discharges air engineering duties. And one of the grave errors that the single judge commits is, he says these allowances are payable even when you are scientist staff. That's one of my main grievances. The issue in this is, I am fine. I have from 29/4/2011, when he assumed the duties of the flight test engineer, I have given him all this. And in fact, at the cost of the audit raising an objection, the audit has raised an objection that he has not actually flown. I mean, he has not participated in air designation duties, but yet you have paid him that amount. Why have you paid is the audit objection raised. But nevertheless, I have paid him. From the date he assumed duties as FT, I have paid these amounts. So that is as far as the payment is concerned. Then, my lord, as far as the promotion is concerned, our residency rule, admittedly, the residency rule says he should have completed 5 years. Now, the respondent says, treat me as having been appointed on 29/11/2016, add 5 years to, in 2016, I became eligible, and the learned single judge accepts that. I am saying you became eligible you became eligible only in 2019. And in 19, he was called for an interview. And in the interview, please see his performance.
In 2019, he was interviewed for which post?
For his promotion from FT2 to FT3. He was eligible for an interview at that point.
5 years residency will be counted from which date?
From the date he assumed as FT, which is 2014. He became FT2 in 2014.
Learned single judge says that from?
Yes, learned single judge says you treat him as, because learned single judge's logic is, he had the qualifications. But he may have had qualifications, but then I have recruited him for an altogether different cadre.
What was that post? Scientist.
Scientist staff, and he willingly accepted it. It is a desk job. It is program management. It is project management, scheduling, and other things. He did not discharge any air engineering duties at all. Prior to scientist staff, he may have done air engineering. But between 2011 to 2014, I called for a specific post called scientist staff. Now he had the qualification for that post as well.
Then why 2 petitions?
I'm sorry?
Why 2 petitions were filed?
No, he first sought for if order 2, rule 2 principles were to be applied to writ petition, the second petition would not have been survived. But then first he sought for promotional benefits, and then he sought for the other relief that the pension should not have been deducted. But my lord, my research points out that order 2, rule 2 principles may not strictly apply to writ petition. So therefore,
just for what everything started.
We'll continue up to 3:45 today, and then 3:45.
3:40.
Please.
I will try to complete by then.
2 words, not why
Then
2?
tomorrow or Monday.
Please. Only thing is, my lords, the organization has persons from 2 streams. One who are directly appointed, others who are drafted from the agencies such as from defense, Air Force, military, and Navy, and so also from DRDO. Lords, we are all from the earlier working with defense organization. I was with Navy. Lords, in respect of another person, he was provided all the benefits, given everything, whereas for me, my pension was being deducted from salary. I said, why you are making, you're going with 2 treatments? I questioned it, and they said, no, your order is like that. For him also, it was like that. When it was questioned, they said, no, it causes difficulties for him. He's about to retire, he will retire. So we'll allow him to take it. For me, they said no. And when the audit objection was raised, specifically it is stated by the organization that we have not adopted the rules, what has been stated to be being relied upon to deduct the pension. For his case, not adopted. For me, it is adopted. That's the reason, my lords, I had to question that action also, and my lords, promotion.
You can argue.
No, just why, the question was why 2 petitions? It was
One
made by me.
one wrong cannot saturate the right decision taken.
No, I'll answer, my lords, all the, queries raised. My lord, definitely, my lord, sir, because there is probation at every point of time. That's the reason, my lords. I'll reserve, my lords.
But, for the promotion, we conducted an interview. Learned Singhal says, where did you get the power to conduct an interview? He finds fault with our conducting interview, which is why I have produced a copy of the
Is it a time-bound promotion according to your regulations?
time bound.
Is it a time-bound promotion according to your
No,
regulations?
I would say the eligibility arises after he completes 5 years of residency.
But he's not entitled to time-bound promotions.
No, but he has to satisfy the assessment and interview. It is not automatic. It is not automatic. In the sense, if your lordship's question is whether after 5 years he should automatically be promoted, the answer is no. It is subject. There were 2 candidates. Another officer made it. There was another officer who made it. Two candidates were interviewed for the post of FT3. That candidate is not. But since the learned single judge has found fault with the manner in which we conducted the interview, may request your lordship to please have a look at the rules. I have produced the recruitment and promotion rules at page 176. Lord, please have a look at page 176. In my writ appeal, where I produced the recruitment and promotion rules. This was also produced before the learned single judge. In fact, this was produced by the writ petitioner before the court. It begins at page 176, but the relevant part is at page 189, titled as Departmental Promotion for Scientific and Technical Staff. It begins at page 176, relevant part at page 199, under para 6.4. Departmental promotion shall be made from amongst the officers possessing the experience as given in Schedule 4 and serving in the next lower grade. Selection of officer for promotion shall be made in accordance with the following manner and on the basis of individual merit. A assessment board as per Schedule 5 shall be convened once a year. The first step in assessment process is screening by a committee appointed for the purpose. The guidelines for screening will be prescribed by the Director General ADA from time to time. Those screened in will be eligible for further assessment stroke interview. If an officer declines to appear for interview before an assessment board, we can skip that. D, all scientists, engineers of the society who have completed the prescribed number of years of service in the grade shall be eligible for consideration of assessment for promotion to the next higher grade under a flexible complementing scheme. E is the most critical part. In evaluating the suitability of the officers for promotion, the assessment board shall take into consideration their performance, merit, seniority, etc. as applicable. The selection shall be on the basis of written test stroke skills test wherever prescribed, confidential report and interview. The assessment board shall drop the list of officers who are assessed as fit for promotion to the next higher grade. But in pursuance of these rules, the committee was constituted. What is the page number? A committee comprising of senior officers was constituted. It is in second volume. Lord, that would your lordship now have a look at the second volume in writ appeal 1348. Page number 436 in the second volume. Page 436. Second one, page 436. Office order dated 20th September 2019. Approval of DGADA for assessment. Based on the approval of DGADA, Secretary, Department of Defense, and as per the scheme of FT, FTP policy of AD. The following committee is constituted for consideration for promotion of eligible flight test engineer 2. Now, please have a look at the designation of the officers. Director General Aero, Chairperson, PGDCA, Director ADA, Member, Project Director, Flight Test, National Flight Testing Center, ADA, Member, Commandant, AST, External Expert. So this committee conducted the interview, and I have produced copies of, Lord, please now have a look at page number 439 and 440. Please let us have a look at 440 first, because that pertains to the writ petitioner. It is in landscape mode. Assessment sheet of FT. The name is mentioned in the center. Interview marks required 85. Interview marks obtained is 81. And recommendations of the board, it says, may not be very legible. It says not fit for promotion. And now I have a look at the previous page. That is 439. One group captain, retired Maltesh Prabhu, who secured 92 marks as against 81 by the writ petitioner. He was considered fit for promotion. Therefore, my respectful submission is that the writ petitioner was not promoted because the expert body constituted in accordance with law did not find him fit for promotion. So, and on this, I have certain authorities to cite. Maybe I can quickly finish off. When the consistent proposition which is laid down by the Honorable Supreme Court is, when an expert body has assessed on the technical side, the wisdom of that expert body cannot be replaced under 226. I've divided my volume of citations into about 5 different propositions. The first proposition is that under Article 226, High Court cannot sit in appeal over decision of a selection committee. On that proposition, I have referred to 2 judgments of the Honorable Supreme Court. The first one is Dalpat Abasai, a 1990 judgment of the Honorable Supreme Court. In this, relevant would be para 5 and 12. To save time, may take your lordship directly to para 12. At page number 5, para 12. Lord, to save further time, para 12, 4th line. It is beginning with the words, it is needless. It is needless to emphasize. It is not the function of the court to hear appeals over decision of selection committees and to scrutinize the relative merits of the candidates, whether a candidate is fit for a particular post or not, has to be decided by duly constituted selection committee, which has the expertise on the subject. The court has no such expertise. One more judgment on this subject, on this proposition, is a 2014 judgment in the case of SP Nair. Begins at page 9, para 13, para 11, page 13 would be relevant. Page 13, para 11, in the Nair judgment. It is needless that it is, it is settled that the High Court under Article 226 of the Constitution of India cannot sit in appeal over the assessment made by the DPC. If the assessment made by the DPC is perverse or is not based on the record or proper record, has not been considered by DPC, it is always open to the High Court under 226 to remit the matter back to DPC. But the High Court cannot assess the merit on which its own on perusal of the service record of one or more of the employees. The next proposition is power of judicial review cannot expand upon the ambit of the prescribed qualification. Why I am saying this is, learned single judge, I will take your lordship through the relevant part of the single judge later. Learned single judge says he anyway had the qualification. He had the qualification for FT2, so you unnecessarily made him sit as scientist F. That is the kind of logic that the learned single judge is saying. I am finding fault with that. Therefore, my lord, I am relying upon Zahur Ahmad Rathar at page number 15. Relevant part is para 26 at page 25. Para 26, page 25, somewhere in the middle, begin about 6th line, beginning with the expression, the prescription. The prescription of qualities for a post is a matter of recruitment policy. The state as the employer is entitled to prescribe the qualification as conditions of eligibility. It is no part or role of the function of judicial review to expand upon the ambit of prescribed qualification. Similarly, equivalence of a qualification is not a matter which can be determined in exercise of power of judicial review. Whether a particular qualification should or should not be regarded as equivalent is a matter for the state as the recruitment authority to determine. And then, my lord, one more, the next proposition is entitlement to similar pay scale depending upon evaluation of duties and responsibilities of the respective post. In this, my lord, the Uttar Pradesh judgment, the Honorable Supreme Court dealt with that issue, begins at page 29. In the case of State of UP versus JP Chaurasia. Para 18 at page 38. 18 at page 38. The first question regarding entitlement to pay scale admissible to section officer should not detain us longer. The answer to the question depends on several factors. It does not just depend upon the nature of work or volume of work done by the bench secretaries. Primarily, it requires, among other things, evaluation of duties, responsibilities of the respective post. More often, functions of two posts may appear to be same or similar, but there may be different in degrees of performance. So, Lord, FTE2 is totally different. It is outside job. There are a lot of risk involved. So it cannot be compared with the FTE2. And then that on the consideration of merit, in the application of principle of merit cum seniority, the next proposition is greater emphasis should be given to merit and ability. That is what the Honorable Supreme Court says in the case of Ravi Kumar Dansukla. So we have given impetus to merit. That judgment begins at page 45. Couple of lines that I want to read is at page 57, para 34. Para 34, page 57. Lord, the last about 6 lines. The law on the principle of merit cum seniority is by now settled by this court in a catena of judgments in decisions. As observed, while applying the principle of merit cum seniority, greater emphasis is given on merit and ability, and seniority plays a less significant role. As observed while applying the principle of merit cum seniority, the seniority is to become weight only when merit and ability are approximately equal. And the last proposition that I am relying upon is that the selection committee need not record reasons. My Lord Learned Single Judge points out that there is no reason for selection or non-selection of a candidate in the absence of a statutory requirement. That is what the Honorable Supreme Court says in the last judgment in the case of Nimhans. In the Nimhans judgment, page 64, Lord, para 7, about 6th line. The selection has been made by the assessment of relative merits of rival candidates determined in the course of interview of candidates possessing the required eligibility. There is no rule or regulation brought to our notice requiring the committee to record reasons. And then the last line, beginning with the word administration. Administrative authority is under no legal obligation to record reasons in support of its decision. Indeed, even the principles of natural justice do not require an administrative authority or a selection committee or an examiner to record reasons for the selection or non-selection of a person in the absence of statutory requirement. Lord, tomorrow, Lordship may have it on Monday. Monday, I will read the relevant part of the Learned Single Judge's order and conclude. So the summary of my submission, my Lord, would be that the Learned Single Judge was wrong in considering that the writ petitioner must be treated to have been appointed from 2011 merely because he possessed qualifications. Lord, I would say that that finding is wrong because Learned Single Judge has mixed both cadres. They are independent cadres requiring different functions altogether. And that is what the Honorable Supreme Court says. You have to look at that. If my submission is accepted that he should be treated as FTE2 only from the date that he assumed charge, which is 2014, then the rest of the finding of the Learned Single Judge will collapse on its own weight. Because the Learned Single Judge says you pay him the allowances from 2011, promote him by considering 2011 date. That would be the essence of assumption. Couple of paragraphs I will show on Monday, my Lord. On Monday also, would your Lordship take it about 3:30 or so? I'll conclude in about 15-20 minutes on Monday, then my learned friend can.
In the second half. Please, later part of the second half.
Later part of this. And then what there is one more. The single judge finally says you promote him from FTE3 to FTE4. FTE4 is a non-existent post. We don't have a post called FTE4. He says, since I am directing you to promote him from 2016 onwards, then another 5 years from 2021, he becomes eligible to next post, which does not exist.
FT4,
FT4,
it doesn't exist.
that post itself doesn't exist.
So learned single judge created post also. Nothing.
I'll answer all the sentence. I'll answer all the conditions, please.